position 13 is off the calendar. So if anyone was on this call for Mr. Clay, I have been told that Mr. Clay does not want to go forward with whatever he was going to go forward with. And you're free if your one connection to this calendar was Mr. Clay to go on your way.
And judge number 14 has been removed as well.
Oh, thank you, Ms. Nelson. And that would be Jose Angeles. Jose Angeles. That is off as well. Those are two cases that were not Judge Farmer. So gosh, I'm gonna be on this call for about 5 minutes and then I'll be handing it over. But let me go through who I will be handling. And then if there's someone who absolutely positively needs to have their case heard first, we can do that. Otherwise, we'll go in the order in which the calendar was published. So we've got Robert Fleming, and I see Mr. Pugh is on the call, and I see we've got Ms. Hall. That'll be the first matter we take, unless I'm told otherwise by someone wearing a badge. Then we'll do Johnny Lawton. I don't see Mr. Oh, there's Mr. Franklin. I see Mr. Franklin. So we're ready to go on Mr. Lawton, assuming the sheriff's got him ready. We will skip 3, 4, 5, 6. Those are all Farmer cases. 7, 8, 9, 10, all Farmer cases. 11, 12. We'll skip all those. And we will do John Williams. It's a Judge Cox case. So we'll try to do, just to repeat, Fleming first, it's a bond hearing. Then Lawton, I believe that's a plea. And then we will jump all the way to Mr. Williams, which is also a plea. Following that, I'll get Judge Farmer on, and all you good people who are here for what looks like a bond calendar galore for Judge Farmer will handle those things.
Thank you.
Now's the time to speak up if we need to do it in a different way. Mr. Forte is ready to roll. Anyone have an issue with proceeding in that order?
No, Judge.
Give us 1 second, Judge, here to jail to readjust our schedule.
No problem. Do you want me to repeat that more slowly, or did you catch that?
No, sir, we got it. We got it. Just give me like 2 minutes. Matter of fact, you can go ahead and proceed. Go ahead and proceed, Judge.
Is that, do we have Mr. Fleming? Is that Fleming and 4 North?
Yes, Judge, that's Mr. Fleming.
Excellent. All right. So we'll do Fleming in just a moment. We'll get on the record for that. And if 6 South, you need more time, you just let me know. I appreciate I threw you a little bit of a curveball, but for planning purposes, after we finish with Fleming, we'll want to pivot to do Lawton, position 2. Let me just get the case files here.
Is it gonna let go? I want you to get locked in. Oh, there you go.
Okay, let's get on the record, Mr. Forte, with position 1. It's State versus Robert Fleming. It's indictment 20 SC 175603. Mr. Fleming is charged with trafficking in heroin, a couple of obstruction counts, and a misdemeanor count of marijuana. He's represented by Mr. Pugh, P-U-G-H. I see Mr. Pugh on the screen next to Mr. Fleming. And I believe Ms. Hall has the case for the state. And today we are only talking about bond. Mr. Pugh filed a bond motion. And we're going to get underway in 1 second. I need to know, Mr. Fleming, that 1, you can hear everything I'm saying.
Yes, sir.
Okay. And 2, I want to make clear on the record that you are waiving your right to be, number 1, here in court. Are you waiving that right?
Yes, sir.
And you're also waiving your right to have Mr. Pugh by your side. You have a right to have your attorney with you, next to you, so you can confer. And if you don't want to waive that right, we'll need to have this bond motion at another time when we can accommodate that. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yeah, I'll wait.
Okay, let me add this, however, if at some point during this hearing, you need to speak with Mr. Pugh in confidence, you just need to let me know, and we have the ability to move you virtually, you and Mr. Pugh, into a private room where what you say, no one else can hear. I won't be able to see you anymore. The prosecutor can't hear you. You and Mr. Pugh, it's almost like you're in a conference room, just the two of you. So if you need that, let me know. I don't think that'll come up in the context of a bond hearing, but it could. And if either of you, Mr. Pugh or Mr. Fleming, need that, let me know. And the skilled technical folks who are monitoring this hearing will move you to that breakout room, okay?
All right.
All right. So Mr. Pugh, why don't you get started and let me know why you think Mr. Fleming should get a bond and what the bond should be.
Thank you, Judge. Judge, he was booked in on February the 26th of this year. So he's been in continuous custody since that time. He has unfortunately, he has a bench warrant out of state court, Fulton County State Court. It's a case that I didn't represent him on it, so I really can't speak for exactly what happened. We've had a bond hearing on that. He's been granted a bond. He hasn't posted that bond at this point because he's got this hold still. So he's got a bond. So if we can get him a bond on this, it would procure his release. He has a residence to stay at here in Georgia. It's 7350 Campbellton, is that how you say that? Campbellton Road. And will come to court. He's retained me to represent him on the case. I don't know where the case is logistically moving forward as far as, going to trial or the status of that at this time. I guess really nobody knows exactly where we are, Judge. But based on the length of time that he's been held without a bond, I think that he's a candidate for a bond. And I would ask that you set a bond somewhere in the range of $35,000 to $50,000. And Ms. Hall, how are you?
I'm good. How are you this morning?
Good to see you.
Mr. Pugh, who resides at the Campbellton Road address right now?
A lady named Taylor Lee, and I believe that's his girlfriend. That's who's retained me on the case.
Okay. And was Mr. Fleming living at that address when this incident occurred?
I can't answer that, but Robert, were you living there when this occurred at the Campton Road address? Is
Yes,
that where
sir.
you live?
Yes, sir.
And
Okay.
Mr. Fleming, is it just Ms. Lee there? Or are there other people who live there besides you and Ms. Lee?
Me, Miss Lee, and my child.
Your children?
Yes, sir.
Okay. And how old are your kids?
5 months.
You have a little baby with Ms. Lee?
Yes, sir.
Okay. And is that a house or an apartment?
Apartment.
So is there an additional part to the address? Is it 7350 Campbellton Road, apartment?
Apartment.
01.
Yeah. 01.
O as in the letter?
Yes, sir.
Okay. And do you know, is Ms. Lee, was she working before she had the child?
Yes, sir.
What was she doing?
She was, I ain't for sure, she was like a medical assistant.
Okay. And is she planning on going back to work when she's able?
Yes, sir.
Okay. Are you an Atlanta native, Mr. Fleming?
Yes, sir.
All right. And how old are you?
40.
40?
Yes, sir.
Do you have any other kids?
Yes, sir.
How many other kids?
I got 6 more.
Are they all in Atlanta?
Yes, sir.
Okay. And what's the last job you had?
Chase Go Estrado on View Howell Road.
And when were you working there?
2018.
And that's like a oil change place?
Yes, sir.
And why did you stop working there?
I just stopped.
Okay. Officer Allen, are you our probation officer for today?
Yes, Your Honor. Good morning.
Good morning. Thank you for dialing in. What can you tell me about any Georgia criminal history that Mr. Fleming might have?
Your Honor, I am seeing several arrests. He's currently on probation in Douglas County for racketeering. He's also on supervision in Twiggs County for possession with intent to distribute marijuana and other drugs. To count the felonies, Your Honor, I'm seeing 6 prior felonies, Your Honor, and that's all I have for now.
Okay, I just want to ask a little bit more about the 2 active cases. So Mr. Fleming is on active probation out of Douglas County, you said for racketeering?
Correct, Your Honor.
And then out of Twiggs County for possession with intent, marijuana, and maybe some other drug charges?
Correct, Your Honor.
And those were being supervised here in Fulton County?
No, no, Douglas County, Your Honor. We have a Douglas address for this defendant.
Not a Campbellton Road address?
No, Your Honor, not in our system.
Okay. And is there a probation warrant for
Yes.
Mr. Fleming in light of these new charges?
Yes, there has been one, Your Honor.
Okay. Ms. Hall?
Thank you,
Good
Your
morning.
Honor. Good morning. I'm really just going to add to what Mr. Allen just told you, Your Honor. But just to give you some facts on this case, officers attempted to pull over the defendant for suspended registration. The defendant fled during the pursuit and trying to arrest the defendant. The defendant bit one of the officers. That's where the obstruction charge came from. The vehicle that he was driving smelled of marijuana, so they searched the vehicle. They were able to recover 18 grams of heroin, which we do have the lab back on. I received that on yesterday. I will forward that to defense counsel. They also were able to recover marijuana and $5,000 worth of cash. The defendant, the state had 7 prior felony convictions for the defendant dating back to 99 through 2015, all being possession of drugs or the intent to sell drugs. And we also had the 2 active probations that the defendant is on. Your Honor, the state is asking that this defendant remains in a no bond status. We do feel that if he is let out on bond, he will reoffend. And that's all from the state, Your Honor.
Do you know, Ms. Hall, racketeering is a broad concept. Racketeering can cover gambling, money laundering, this and that. Do you know if it was a drug-related racketeering case out of Douglas County, or you just know it's racketeering charges?
I just have a violation of racketeering, Your Honor.
Okay, got it. All right, Mr. Pugh, anything you want to add? I want to make sure you get the last word as the movement here.
Thank you, Judge. And Judge, I knew we had some prior and some other issues. I was unaware that warrants had actually issued out of Douglas. I don't know that the jail's showing those yet, but if they've issued, of course, a bond would just move him to another jurisdiction to allow him to go ahead and start working on getting those probation matters worked out as well. So I still would ask for a bond. I think the range of 35 to 50 is appropriate. And if it just moves him to Douglas County so he can start working on his probation, so be it. He is requesting a bond.
Okay. Do you know what the state court charges are, Mr. Pugh? You mentioned there had been a bench warrant, but that's been addressed.
It was battery, Judge.
Okay.
It was a very old case. Let me see if I can. Jen, where do we have? I know we had. Did you just pull it up a second ago?
Yeah, that was the other one.
Okay. It's a battery charge, Judge. And it was from
Okay.
2014. So it's 6 years old.
Got it.
How it didn't catch up to him when he was reporting to probation, I don't know, but it didn't.
Got it. Ms. Hall, one last question for you. The basic description you gave of the allegations with the traffic stop, was there only one person in the car or were there multiple people in the car?
The defendant was the only person in the car, Your Honor.
Okay. So, Mr. Fleming, I understand, of course, your desire to not be where you are now, but I'm not going to set a bond in your case. I find that there isn't a set of conditions I could impose that will keep you out of trouble. You were on 2 cases, felony cases with active probation, and with kind of serious charges, especially out of Douglas County. Probation has you with a Douglas County address. You want to say something?
Yeah, I'm not on probation in Douglas County.
Well, I hear you saying that. I hear probation saying otherwise. I also hear probation saying that when they look you up, they have a Douglas County address. Mr. Pugh will be able to look into this on your behalf. We can always talk again. But I'm hearing from probation that when you got pulled over in this situation that brings us together, you had 2 open cases, and that wasn't deterrent enough for you to get mixed up with whatever you got mixed up in. So I don't think that bond is appropriate. I'm going to leave you in a no bond status. That said, if Mr. Pugh does a little more research and learns from probation that our data is a little mixed up and those are old cases or it wasn't you, I'm happy to have this conversation again. We can do it pretty readily. But based on what I'm hearing, I don't think that you are an ideal candidate for bond. Not real clear what your stable address is, but even more so, I am concerned about your ability to stay out of trouble between now and whenever we resolve your case. Ms. Hall is going to be getting some important information to your lawyer, and it may be that this is a case that can resolve short of trial. To answer your question, Mr. Pugh, about what's next with the case, has Mr. Fleming been arraigned yet?
Not to my knowledge, Judge. Has he?
All right, well, let me ask, is he going to want a formal arraignment, or if we get you the right paperwork, will you file a waiver of arraignment on his behalf?
I could probably file it, Judge. I would like to talk to him. What I need to do is come out, just make a trip out to the jail and sit down with him again and talk to him.
Sure.
About this. And usually I waive arraignment, Judge.
Okay, well, I leave that up to you. I'm not pressuring one way or the other, but as soon as you sort that out, we can get the case moving along. You're going to want to digest the discovery. There may be motions to suppress here that could be rather dispositive. It may be that there's not, but those kinds of things, I suspect in the fairly near term, we'll be able to work through, meaning a suppression hearing. Not a jury trial, that is in the distant future, but a suppression hearing, I would think in June or July, we'll be able to do something like that if that's where this case is heading. And certainly we can take pleas whenever the parties are ready for that, if that's where this case is heading. And I leave that to the lawyers 100%. But I did want to give you some guidance, Mr. Pugh. This isn't a case that's just going to get stuck. But it can move along as soon as Ms. Hall's getting you that discovery, you're having a chance to talk with Mr. Fleming, we can get it moving. But I'll repeat what I said. If you learn, Mr. Pugh, that the probation information is other than what we just talked about, we can reconvene. But based on what I've heard, Mr. Fleming's going to sit tight and we will see him for another proceeding. Thank you.
And Judge, may I ask Ms. Hall, would you be so kind, could you either email me your contact information or your direct number so I can just reach out to you? Is that okay?
I will. I'll just give you my number now. It's 678.
Yes, ma'am.
755-6485.
Thank you so much. Judge, thank you. Y'all have a great day.
All right, thank you, Mr. Pugh. Nice to meet you, Mr. Fleming. We'll see you soon. So next up should be Johnny Lawton. Is that Mr. Lawton on the 3 South window?
Yes, sir.
How you doing, Mr. Lawton?
Bless you.
Good. Mr. Forte, are you ready to pivot to the next case? All right. Position 2 on our calendar is State versus Johnny Lawton. It is 19 SC 172503. Mr. Lawton is charged with burglary. He's represented by Mr. Franklin, who is there today. Hello, Mr. Franklin.
Good morning, Judge.
Paul has the case for the state. And my understanding, Mr. Franklin, is that Mr. Lawton is going to try to enter a plea in his case. Is that right?
That's correct, Your Honor.
Okay. Mr. Lawton, I need to cover a couple things with you, and then I'm going to hand it over to Ms. Hall, who's going to ask you a bunch of questions if we're going to go forward with the plea. The first is, you need to make sure that you are waiving your right to be here in court. You have a right to be here in court, but of course it's complicated times. You're wearing that mask and we're all remote, and you're free to waive rights. You just need to let me know that you're willing to proceed virtually, meaning you're there at the jail, your lawyer is somewhere else, and I'm here in court. Are you okay with that?
Yes, sir.
Okay. The other thing I need to make clear on the record is that you are comfortable, meaning you're waiving your right to proceed without your lawyer sitting by your side. Are you okay with that?
Yes, sir.
You should know, Mr. Lawton, that if you need to speak with Mr. Franklin, we can move the two of you virtually into a private room where the two of you can talk and no one can see or hear it except for the two of you. So if you need that, you just raise your hand, let me know, I'll ask you what's going on. And if you need to speak with Mr. Franklin, we'll move the two of you into that breakout room. But hopefully the two of you have spoken and you know more or less what's coming down, okay?
Yes, sir.
Mr. Franklin, have you had an opportunity to discuss with Mr. Lawton what we're going to try to do today?
Yes, Your Honor, I have. And I explained to him that it may be a bit different from what others have done because it is non-negotiated.
Okay, but you're comfortable proceeding in this format?
Yes, sir.
All right, last thing, and then you can start, Ms. Hall. I have the original indictment right here, so at the appropriate time, I'll be signing for everyone if we get that far, but I do have the original. We will not be working off of a copy. So, Mr. Lawton, in just a moment, Ms. Hall is going to swear you in. You're going to raise your right hand just like that, and she's going to see if you will take an oath to tell the truth. Once you're under oath, it's important that you answer her questions and mine. We're both going to have questions truthfully and completely. Will you do that?
Yes, sir.
It's also important that if we ever say something that you cannot hear, you don't understand, or just doesn't make sense, that you let me know that as well, so we can try to explain it, or that we get you and Mr. Franklin into one of those private rooms, okay?
Yes, sir.
Great. And last thing, so that Mr. Forte, the court reporter, can take down everything that's said, you need to make sure that you verbalize your answer. So you're free to nod or shake your head, but make sure you say words while you do that, because Mr. Forte cannot write down yes if all you do is this. Okay?
Yes, sir.
Great. Ms. Hall?
Thank you, Your Honor. Mr. Lawton, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Mr. Lawton, do you waive an original signature, your signature on the indictment?
Yes, sir. Yes, ma'am.
Okay. Can you please state your true, correct, and legal name?
Johnny Bernard Lawton.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'll be 45 on Friday, and I went to the 10th grade.
Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with 1 count of burglary in the 1st degree?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer, Mr. Franklin, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, if any.
Mr. Lawson, have you been arrested on this charge?
Yes, ma'am.
I ask you that because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No, ma'am.
No, ma'am.
No, ma'am.
Okay. Mr. Lawson, has your attorney advised you of the minimum and maximum sentence to the charge that you're pleading to?
Yes, ma'am.
The minimum and maximum sentence to burglary in the first degree is 5 years to serve 25 years, being that this is the third conviction for burglary. Do you understand that do you understand that if your guilty plea is a blind plea, also called a non-negotiated plea, the state will still make a recommendation to the court?
Yes, ma'am.
Are you aware of the state's offer?
Yes, ma'am.
The state's offer for burglary in the first degree, Your Honor, is 10 years to serve 5 years, balanced on probation. Mr. Lawton, do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence for this charge?
Yes, ma'am.
Do you understand that if you enter a non-negotiated plea, you do not have a right to do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction? Just as there would be from a conviction following a trial. For example, your guilty plea may affect your right to vote, your right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charge of burglary in the first degree in indictment number 19 SC 172503?
Plead guilty. Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, if this case had proceeded to trial, the state would have proven that on October the 17th, 2019, officers were dispatched to 679 Jones Avenue, Northwest Atlanta, Georgia, in Fulton County, in reference to a burglary call. Upon arrival, they met with a witness, the property manager of the location, who stated someone had broken into the construction home that was being built, and they tore out all the copper wiring. All the copper wiring was stripped from the kitchen, and the window was broken as well. That was the point of entry of this construction home. There was a witness across the street that took a picture of the defendant while he was on the property and when he was leaving the property. When officers were there, they saw a person matching the same description as the defendant, wearing the same clothes that they had on in the same picture that was taken a few days prior. And they approached the defendant. The defendant did admit to taking the copper wire and having it scrapped, and he did inform them of the money that he received from that copper wire. The defendant was arrested and charged accordingly, Your Honor. And as far as his criminal history, one moment, the defendant has a total of 7 prior felony convictions, 4 in which are burglary charges. 2 are first-degree burglaries that occurred. The first first-degree burglary was, the case number is 01SC00928. That was a conviction out of Fulton County. The disposition date was August the 16th, 2001. The second burglary was, the case number is 09SC82991. That burglary was out of Fulton County as well. Disposition date of September 15th, 2009. And he has 2 other burglaries, those being disposition dates of May the 21st, 2019. That was a second-degree burglary, though that case number is 12SC116096.
It's a 12 SC case, but the plea was taken in May of last year?
May of 13. I'm sorry if I said 19. 2013.
Okay.
And then the final burglary was a 15 SC 132245. That's a burglary in the second degree out of Fulton County, and that disposition was February the 12th, 2015.
So you said he has 7 priors. Does he have a felony more recent than the 2015?
No, the 2015 is the last conviction that we have for him, Your Honor.
Okay. Officer Allen, is Mr. Lawton on active probation for any of those cases?
Yes, Your Honor. The last 2 cases Ms. Hall previously mentioned were the burglary cases, the 12 SC case and the 15 SC. For the 15 SC, Your Honor, he has 5 years, 7 months, and 1 day remaining. And on the 15 SC case, he has 2 years, 5 months, and 12 days remaining. The 12 SC case belongs to Judge LaGreur. He has an active warrant for that case. And for the 15 SC case, there is a warrant pending Judge Ellerby's signature. It hasn't been signed yet.
Okay. Got it. Thank you. Mr. Lawton, did you say that you turned 45 on Friday?
Yes, sir.
Meaning today's Friday. Is today your birthday?
Next Friday.
Next Friday. All right. Well, early happy birthday to you. Mr. Franklin, what do you want to tell me?
Thank you, Judge. So Mr. Lawrence told you the first piece. He's 45 years old. He has spent 27 years of his life dealing with a crack cocaine addiction and a powder cocaine addiction. The latter portion of that, about 20 years of such, has been compounded by the fact that he's also been homeless. He's been in custody about 205 days to this point, and he has, on his most recent conviction, he received some prison time for that. I believe he was released in about between 12 and 18 months on parole. He did do RSAT. He did well for a period of time upon being released. He managed his addiction. He stayed out of trouble, but he relapsed. And because of the relapse, he fell back into some old habits. And I believe that this was predominantly caused not just by bad decisions, of course that's a part of it, but also by the fact that being homeless, he began to hang back around an area that wasn't good for him, the English Avenue area, as most of us Atlanta area residents know as the Bluff, and we know his reputation. Most people will hear his record and then hear my request of a 10 to serve 3, and for the 3 years to be reduced to time served upon entry and completion into a program, and that program is Ark Refuge Incorporated. Eyebrows may raise when I make this request, but part of why I'm making it is because a large portion of this weight has been carried and decided to some extent by Judge LaGrua. He's already appeared before Judge LaGrua on the 12 SC indictment that we've mentioned before, and he's been revoked for 2 years, 10 months, and 8 days. However,
When did that happen?
that revocation, just a second,
Ballpark.
a few months ago.
Okay. And she revoked, you said 2 years and 10 months?
2 years, 10 months, 28 days. This occurred February 11th of this year.
Okay.
But she also, reduced it to time served upon entry and completion of a minimum of 9 months of treatment. So that perked my ears up and let me know that we needed to start looking for treatment options, because I've never appeared before Judge LaGrua, but I know that her courtroom is not a playground. And I know that she has pretty good relationships with those persons that come before her. So with that in hand, we began to look at program options. We were able to get him accepted into Ark Refuge, and it's a 12-month program, which is 3 months longer than what she recommended. It has a daily schedule that includes prayer. Sorry, I'm duty attorney and I have my phone on as well. They have a daily schedule that starts at 5 a.m. and goes to about 11 p.m. It's located in LaGrange, Georgia, so he would not be in the Atlanta area. And it is a recovery first kind of program where their goal is to teach residents the skills necessary to be successful with their recovery and their rehabilitation. They report monthly. They provide monthly status updates regarding his participation in the program. So if he's not compliant, the court would be able to know that readily. And that arrangement can be made with the probation office who supervises him. And if he's terminated from the program, the court and probation office would be made aware. So I think what we have is a person who has shown some ability on his own to have some success in society dealing with his addiction. But without more regimented resources available to him, it's kind of a natural path, I hate to say, where relapse will likely occur until he is stabilized with the home and eventually, hopefully, job support. So we are asking for this sentence, which effectively amounts to about a 7-year probated sentence that he would have 3 years to serve if he doesn't complete the program. Because we think that a situation that's a copper burglary, certainly a crime. We're not trying to lessen what it is, but I do think that we have ranges of kind of how egregious certain conduct is. And a man who has shown that he takes his addiction rehab seriously, but just doesn't have the equipment necessarily to deal with it on his own, I think he's the proper kind of candidate for an opportunity such as this. We do believe that a condition that he stay away from the English Avenue neighborhood should be provided, because that, in my estimation, appears to be his trigger. And if it's anybody whose family that he needs to see who lives there, they can make arrangements to not do so within that area because it has a reputation in our community. And that's our request, Your Honor.
Okay. Mr. Lawton, where are you from? Where were you born?
I was born in the Bluff, in Atlanta.
Oh, so that's home.
Yeah, I've been there.
Okay. Do you have family that lives still in that area?
I just got a cousin stayed up, but everybody else gone.
Meaning deceased?
No.
Meaning they've moved?
Yeah, they moved. My mother died. My mother died in '88. My father died in 2004. I just lost my baby sister to cancer on Christmas. I pretty much been on drugs all my life, and due to my criminal background, as you read, I got a serious problem, and I really do need the help. I really do.
It sounds like it. I hear you, and it's good that you recognize that. That's a good first step. So what I heard you say is that you no longer have, other than one cousin, family in the Bluff.
Yes, sir.
Okay. Do you have family that lives outside of Atlanta?
Yes. My brother, I got a twin brother. Well, he's staying on Kaylin, Georgia.
Where's that?
That's on the other side of Johnburg.
Okay.
Johnburg, Georgia. Yeah.
Okay. Is there anything you want to add, Mr. Lawton?
I just want the opportunity to get a chance to change my life. It's been so long, I done lost a lot in life, and I'm tired, Your Honor. I'm really tired. I was determined to, when I talked to my social worker, my lawyer, and I told him my situation, and I just can't take it no more. I'm a diabetic, and I take medicine, and I know what goes on out there in the world with the coronavirus. I ain't trying to, go out no time soon, but I just thank God for what he did to me, and hopefully I can get the chance to be somebody before it's too late.
Got it.
Yes, sir.
So why do you think, Mr. Lawton, that ARC Refuge would help you in a way that RSAT did not?
Well, I never got a chance to do a challenge. I did good at RSAT, yes, I did. And I completed, and I did good. But the thing about when I got out, I didn't have the resources that I need. Stepping out like that again, it just triggers my mind to just go back and do that. If I had a chance to be in a environment around people that, I want to be on that level, like Christian people, church, being close to God, that's all I ask for, to change, not change an environment that put me back out there. Because every time I get out, I go back to the same thing the first day, Your Honor.
Got it.
And yeah.
Ms. Hall, it sounded like from your description that this was a dwelling, which is why it's first-degree burglary, but it was unoccupied. It was a house they were either building or they were rebuilding, and that's why Mr. Lawton had access to all the wiring.
That is correct, Your Honor.
Is there restitution in this case?
So the restitution is over $20,000. Had a long conversation with the victim yesterday about that. He understood. That's the restitution.
Okay. All right. So, Mr. Lawton, Mr. Franklin, tell me how ARC Refuge works. And I mean that in two ways. One, you said this is a longer program, meaning if Mr. Lawton makes it there and stays there, it would be expected that he remain residing there. I saw the brochure you sent, 55 beds. It's a residential treatment program that he would be expected to remain there for a year?
At least a year, yes, Your Honor.
Okay, and that would be their expectation of him, but if Mr. Lawton did well, he could expect of them a roof over his head and guidance and treatment and whatnot for a year.
Yes, sir. Job training and assistance will be part of the transition. The goal is to, for lack of a better term, guide someone into a stable, independent situation such that they can sustain themselves, which is something that he didn't have through RSAT.
How does this get paid for?
It's a nonprofit. I think they just kind of have their own funds. It's not anything that taxpayers or I'm not aware that he has to provide any kind of payment. My social worker, Nicole Bearden, dealt with them more directly. I think it works a lot like if you're familiar with the Better Way Ministries.
Mm-hmm.
I'm told they're very similar programs. I know a Better Way will have people do on-campus work and kind of pay their way through their on-campus work. Looking at their daily schedule, there are chores that are scheduled throughout the day from 7:30 to 9 and later in the evening, I believe. So they're self-sustaining, essentially. There's no pressure on him to seek outside income.
Okay. How did you all find this place?
Our social workers have relationships with a number of persons. We originally sought a Better Way, but because of his diabetic medical issues, that was something that they were not able to handle, or they didn't feel that they could handle. So we then sought something similar because we wanted something outside the city. Mm-hmm. Because these tall buildings in this air, the familiarity just kind of leads to familiar behavior. We wanted something that was residential, and I think just my social worker and her wealth of experience and her relationships identified these people and arranged a phone call during the quarantine time to have them speak with one another and get it worked out.
Officer Allen, if Mr. Lawton were accepted into the program and that was a special condition of his sentence, would he be subject to supervision by DCS officers from Troup County or whatever county LaGrange is in, or would he be subject to supervision out of Fulton because that's where the case came from?
Be out of Fulton due to the case, Your Honor.
And why would it not be Troup County because that's where he would be residing?
Well, he would be under courtesy supervision for Troup County, but the case still belongs to Fulton. Therefore, if he were to have a violation in Troup County would transfer that to Fulton County, and we would have to address those violations. Okay.
All right. So the courtesy supervision, but ultimately, if hypothetically Mr. Lawton were to walk away from the program after a month, or they kick him out because he wasn't doing something, he was doing something he should not have been, that gets bounced back to us.
Yes, Your Honor.
Okay. Mr. Franklin, what is your understanding about ARC's ability to take Mr. Lawton, not today, but in a month or two? I mean, how is that working? I don't know that there's transport right now. I don't know that I'd necessarily sentence him to reduce the time served as opposed to maybe a little more time and then release two upon the opening of a bed. What do you understand that dynamic to be? Because even if I followed your recommendation, there is not a bus running right now from Rice Street to Troup County.
If you give me a moment, I want to make sure that I'm not confusing it with a different case.
Okay.
But I do believe that they are currently open and accepting people. So if theoretically, if transport were available tomorrow, I believe that they are actually accepting persons. I need to see if there are conditions because I know there are some places that are opening, but they have to get a COVID test. Give me 1 second. So I received an email from my social worker, Nicole Bearden, on May 11th. ARC Refuge told her that they have resumed intakes. So we'll just have to call to see, make sure that bed space is actually available.
Okay.
And figure out the best mode of transportation, which in this set of circumstances would probably involve me arranging through my office to physically take them down there. Because I think it'll be a lot longer, or I mean, you may want for it to be longer, but they are accepted right now.
Okay, got it. So, Mr. Lawton, I hear you that you are wanting things to turn out differently. I think everyone does. It sounds like people are getting pretty frustrated. You fall into this cycle where addiction gets you to break the law. You're not out there hurting people. You're not mugging or robbing or anything like that. But of course, it is disruptive and destructive and expensive for the folks whose property you take. I'm sure you did not get a lot of money for the copper, and I bet that money went away real quickly to drugs, and there was basically nothing to show for it other than a big hole in the pocket of the folks who were trying to renovate that house on Jones Avenue. So we do need to help you break this cycle. I appreciate the state's recommendation. It's one that would shake you a little harder because you'd probably be with the Department of Corrections a little longer than you have been in the past. I also appreciate what Judge LaGrua did with her revocation. It's a meaningful revocation, but it is one that can be reduced if you are able to get into a treatment program that is long enough to hopefully make a difference. And it sounds like Arc Refuge is one of those programs, and in fact would be longer than what Judge LaGrua had in mind. Well, let me say this first. I find that there is a factual basis for your plea. It sounds like you were pretty straightforward with the officers. You admitted what you did. Unfortunately, you weren't able to give the copper back. You'd already sold it, the wiring. I also find that your plea is knowing and voluntary. Knowing means you've understood all the things we've talked about. Is that a fair statement? Do you agree with that?
Yes, sir.
Do you have any questions for Mr. Franklin or for me right now?
I just want to say thank Mr. Frank for riding with me through this and helping me through all this, and he was a great lawyer. And I want to thank you for understanding my situation, Your Honor.
Okay. Well, you're welcome. And Mr. Franklin says you're welcome as well. I'm glad he was able to help you in this way. We're not there yet, so don't celebrate. But the other thing I found is that your plea was voluntary. That means no one has forced you to enter this plea or tricked you in any way. Do you agree with that, that you're entering this plea because you think it's the right next step for you?
Yes, sir. Yes,
okay.
Sir.
All right, I'm thinking right now about how to spell out the sentence, so just give me a second. Okay, Mr. Lawton, I'm gonna sentence you in this case along the lines of what Mr. Franklin has asked for. It is a sentence that I think is appropriately structured to try one last time to restore you to a state where you can be helping yourself stay out of trouble, because ultimately that's who it's got to be. It isn't really anyone else's job when you wake up in the morning to make sure you stay out of trouble. That's your job. But that's not easy to do. And it sounds like for decades now, you've struggled with addiction, and it pulls you back into this cycle that we've seen repeat itself. So I'm going to sentence you to the only count in your indictment to a term of 13 years to serve 3 years. Those 3 years will be reduced to time served upon your entry into the ARC Refuge program. And the way we'll structure that, and I'll need to get some guidance from Mr. Franklin, ARC's not going to come pick you up. I'm not going to require the sheriff's office to take you to ARC Refuge. What Mr. Franklin's going to need to sort out through his team is how that transportation is going to work. You are not going anywhere until I sign a transportation order that will make very explicit who is picking you up, when they're picking you up, and where they're taking you. The where is clear, that's to ARC Refuge. But you're going to be sitting tight until those logistics can be worked out. I'm making it a special condition of your probation that you complete at least 1 year of the residential program at ARC Refuge. I'm also making it a special condition of your probation that you stay out of Fulton County. It doesn't sound like you have any reason you need to be in Fulton County. You got that one cousin, but if he's living in the Bluff, as Mr. Franklin mentioned, he can come see you, or she, if you need to spend time with that person. But you and the Bluff are a bad combo. And the easiest way I can think of it is just don't come to Fulton County. You're going to be far from Fulton County while you're at ARC Refuge. And if they are helping you with job readiness, the kinds of jobs that you're going to find initially are going to be down there and not up here. And so you may be rebuilding and reinventing a life for yourself, but it's going to be outside of Fulton County. So if you get arrested in Fulton County while you're under this sentence, that could cause me to revoke all of your remaining probation, because it's a special condition of your probation that you stay out of Fulton County. I'm also going to require that I get monthly updates from ARC Refuge that you're still there. So we'll need to sort out those logistics, but I'm going to need to get a report from ARC Refuge. It can be an email, doesn't need to be detailed, saying Mr. Lawton is still there and he is in good standing. If I don't get one of those reports, that'll be a reason for me to reach out to probation to say, what's going on with Mr. Lawton? And of course, if you get terminated from ARC Refuge for whatever reason, or you walk away from it during that first year, that's violating a special condition of your probation. And that would leave that whole 10 years of probation for me to work with. And it sounds like you'd be sideways with Judge LaGrua. And I say that not because I'm threatening you in any way. I just want there to be motivation beyond your desire to stay out of harm's way that will keep you focused. This is your last best chance. I'm impressed with the research that the Public Defender's Office did. ARC Refuge is not a fly-by-night program. It's legit, it's out there, and you're being given a chance to participate in it. If you walk away from it or you don't comply with their requirements, that's going to tell me that the way we're going to keep you safe and the way we're going to keep you clean is by sending you to the Department of Corrections for the foreseeable future. And that's the least productive way to do it. It's the least productive, but it'll certainly keep you from taking copper out of houses on Jones Avenue. So I hope that's not how it plays out. But that's how I envision structuring it. That is a slightly longer sentence than what your attorney asked for. So you have the ability, Mr. Lawton, to withdraw your plea if that's what you want to do. You want to think about it for a minute, or do you know what you want to do?
This is what I want to do.
Okay. Mr. Franklin, anything you want to say to Mr. Lawton about what I just pronounced in terms of the sentence?
No, Your Honor, I do want to reiterate, make sure that he heard the nature of the special condition. So it's an entire year that he must participate. And if he doesn't do the year, that's possibly 10 years in prison. I just want to make sure that that's the part that's understood, because that's the biggest difference in kind of what we said.
I got one question to ask.
Okay.
I got one question to ask. How long is I'm banned from Fulton County? I got children and grandchildren in Fulton County.
Okay, I didn't know that. How many children do you have?
I have eight. I have eight adult kids, and I have 4 grandkids.
Okay. And all 8 of your adult kids live in Fulton County?
Yes, sir.
I think when we did the questioning, Your Honor, it was specified as to whether anyone still resided in the Bluff.
Okay.
But that might
And
be
I
good.
don't need you to spell out where all 8 of your kids live, but do any of them live in the Bluff?
No.
But they all live in Fulton County?
I live in Fulton County.
Do any of them live not in Atlanta, but like East Point or College Park?
Well, two of my kids live in South Fulton.
The city of South Fulton?
Yes, sir.
Okay.
The rest of them live inside Fulton County, around the West End area, Midtown, somewhere up in there.
Are your kids all on speaking terms with each other?
Yes, sir. Yes, sir.
Okay. Then here's how I'm going to change it. Because the answer to your question would be, for 10 years, you cannot come to Fulton County. But that was before I knew that you were a dad and a grandpa. And if you are clean and sober and productive, it would be good for you to be in your kid's life and your grandkids' life. If you're strung out, I don't want you anywhere near them, because you're just going to take their money and their stuff, and that's going to be bad.
I understand that totally.
So here's how I'm going to restructure that special condition. While you are on probation in this case, the only place you can be in Fulton County is South Fulton.
Okay.
So your other kids and your grandkids, they can come see you at one of your kids' house in South Fulton.
Okay.
But if you get pulled over for speeding, or you run a red light, or you're jaywalking, and you're in Atlanta or Alpharetta or East Point, that's a violation of your probation. No Midtown, no West End, South Fulton, or you're out of Fulton County. Do you understand that?
Yes, sir.
And I'm not trying to be hard-nosed, but I need the lines to be real bright. Because if I say don't be near the Bluff, I'll be sort of near the Bluff. I wasn't in the Bluff, I was sort of near the Bluff. And I don't want us to have to quibble about where were you. So if you're in Fulton, you're in South Fulton, as in the city of, not just the south part of Fulton County. Otherwise, you're not in Fulton County. We can revisit that. I want to tell you, if you end up getting a great job and that job is in Union City and you need to be there for work, then Mr. Franklin will reach out. And if we can verify that you're employed and you've been clean for 6 months and you need to work in Union City, we'll have that discussion. But we are far from that. Our number one goal is to get you clean and to get you out of trouble. But eventually you're going to want to plug back in with your family if you are sustaining your sobriety, and we can try to make that happen. So the special condition is you stay out of Fulton County except for the city limits of South Fulton.
Okay.
Officer Allen, did you have a question?
Yes, Your Honor. I did want to mention that Mr. Lawton does have to report to our office for intake purposes so we can confirm his living arrangements when he completes the program as ordered. So I just wanted to mention that as well before he was banned from any other portion of Fulton County.
No, I understand that. And it also may be that if Mr. Lawton is visiting family in South Fulton and a tree falls and busts his leg, an ambulance takes him to Grady, and that's okay. Those types of things aren't going to be an issue. But if it comes to law enforcement's attention because he gets arrested or something like that, and that arrest occurs outside of South Fulton, then there's going to be a conversation that we all have in court. That's my emphasis. But if structurally he needs to be in Fulton County because of work, or it turns out because of the diabetes, he's living in Clayton County, but because of the diabetes, the treatment has to be at Grady, then Mr. Franklin can bring that to my attention and we can modify it. So I appreciate your point that day one, after he's done with Ark Refuge, if he's coming back to Fulton, he needs to report to your office on Memorial Drive. But day two onward, he's not going there or anywhere else other than the city of South Fulton. Now, we have two more things we need to take care of, assuming you still want to go forward with this, Mr. Lawton. Did you have any other questions?
No, sir. No, sir.
Judge, I'm sorry, Judge, to interrupt. Is this going to be under Palm?
It is, thank you.
Okay.
So I'm sentencing you pursuant to the Probation Options Management Act, Mr. Lawton. And what that means is that if you have a technical violation while you're on probation, something minor, you and probation will work that out. It's only if you get new charges or you violate a special condition of your probation, you get kicked out of ARC or you're found in Fulton County outside of South Fulton, that the case would come back to me.
Okay.
We need to sort out signing the indictment, and we need to figure out what we're going to do with Judge Ellerby's case. I am comfortable handling that revocation right now. Judge Ellerby has told me in the past she's all right if I handle her matters, and I'm prepared to revoke Mr. Lawton for a year and reduce that to time served upon his entry into the ARC Refuge program, and then suspend that balance because there'll be a much longer balance on this case. But Mr. Lawton did not have notice that we might work through Judge Ellerby's case. So Mr. Franklin, you need to waive that notice, due process notice right on his behalf if we're going to take care of that.
We do waive notice, Your Honor, and ask to proceed with the revocation.
Okay. Officer Allen, I wasn't clear. Is it the 15 SC or the 12 SC that is Judge Ellerby's case?
15 SC, Your Honor.
All right. And can you repeat that case number?
15 SC 132245.
I need you to say it one more time.
15 SC 132245.
245. Okay. So what I'm going to do, Mr. Lawton, because of your new conviction in the 19 SC case, in the 15 SC 132245 case, I'm going to revoke a year of that probation. You will get credit from the day of your arrest, which sounds like was October 17th, 2019. I will reduce that year to time served upon your entry into the ARC Refuge program. And I'll suspend the balance. So what will be still open when you finish ARC Refuge, if we take a positive view, is your probation in this case. And I don't know, there may be a little bit left in Judge LaGrua's case, the 12 SC case. I think that's it, other than signing the indictment. Ms. Hall, I want to reiterate, I think your recommendation was a reasonable one, given the history and the fact that there were two open cases. But I am going to give Mr. Lawton the opportunity, see if he will take advantage of it to benefit from ARC Refuge. If that doesn't go well, then he'll end up with a sentence that may be actually more severe than what you asked for. So he holds the future in his hands. Did you have anything else, Ms. Hall?
No, thank you, Your Honor. And the state waives the original signature on the indictment and authorized the court to sign on our behalf.
Well, great. Then I don't have to ask you that question. Mr. Franklin, do you have anything else beyond me signing on your behalf on the indictment?
No, Your Honor, nothing else. And I'll waive and authorize the court to sign for me as well.
Okay. Mr. Lawton, you need to sign the indictment. That's the way that you indicate that you are going forward with your guilty plea. Obviously, you can't do that because here's the indictment right here and you are there. Do you waive your right to sign the indictment and authorize me to sign it on your behalf, Mr. Lawton?
Yes, sir.
All right. Well, Mr. Lawton, you got the possibility of a brand new chapter in your life when you get down there to ARC Refuge. I encourage you to do the right thing with it. And even if at first it seems like it's a tough program and they're challenging you, I hope you rise to the challenge. You're 45 and you're man enough to do this. If you don't, you aren't leaving us with another option other than to say, well, we'll keep you clean and sober because you're behind bars. And like I said, that's just the least productive way of doing it. But if you force our hand, that's what we're going to need to do. Okay.
Yes, sir.
All right. Well, I'm going to sign on everyone's behalf and we'll get the file back to the clerk's office. And that is it for Mr. Lawton. Good luck, sir. And again, early happy birthday.
All right, thank you.
Thank you, Your Honor.
Happy birthday, Mr. Lawton. I'll give you a call later.
All right, thank you.
Thank you, Your Honor. Thank you, Ms. Hall.
Thank you. Your Honor, that concludes my business. May I be excused?
Yes, ma'am.
Thank you.
Likewise, Your Honor. May I be excused?
Yep. You guys have a good weekend.
You too, sir.
I'm just signing here and then we will turn to the last matter I'm handling, which is John Williams. I understand that's going to be a plea. I see Ms. Calloway on the call. Who's handling it from the DA's office?
This is Sue Chan, Sauchan.
Great. All right. We've got everyone. Give me a second and we'll get going. Ms. Nelson, should I just put the signed indictment back in the file in the little pocket, or do I need to do something else with it?
No, it goes outside the pocket on top of the file and it's dropped off at the clerk's office.
So I should
Or
clip it.
you can scan it to me and I will e-file it, whichever is your preference.
Okay, so I could clip it to the outside of the file, and I may see who is in Judge Farmer's office to see if they would be gracious enough to handle it.
Okay, that'll work.
Yeah. Yeah. Best time I hear she did that. All right, good.
All right, sorry for the delay. I don't have the John Williams case file. It was a last minute addition to the calendar, not through Judge Cox's team's fault. It was supposed to be on the calendar and it slipped through the cracks. So when I got all the files from the clerk's office, it was not included because those were delivered about a week ago. So let me get into Odyssey and pull up the indictment, and we'll have to work off a copy, unfortunately, but hopefully that won't give anyone heartburn, and then we'll get on the record.
Thank you, Your Honor.
Thank you, Ms. Nelson.
You're welcome.
All right, Mr. Forte, are you ready?
Yes, sir.
Great. We now are turning to indictment 19 SC 173240, State versus John Williams. Mr. Williams is charged with aggravated assault. This is a case from Judge Cox. We have Ms. Chan from the DA's office representing the state, and Ms. Calloway is on representing Mr. Williams. And Mr. Williams, I assume that's you on the screen that says 4 North.
Yes, sir.
Great.
Yes, sir.
Good morning, Mr. Williams.
Good morning.
As I understand, this is going to be a plea. Is this a negotiated plea, Ms. Calloway?
Yes, Your Honor.
Okay. Mr. Williams, in a moment, Ms. Chan is going to put you under oath. She's going to ask you to raise your right hand just like that. I'll be able to see your hand up. Once you have accepted that oath, it's important that all your answers to Ms. Chan's questions and mine are truthful and complete. If you have any questions of your own, let us know when you've got them, and we will work through those. Before I get you under oath, I need to make sure that you are waiving your right, Mr. Williams, to be here in court with me. Are you willing to proceed virtually as we are?
Yes, sir.
You also have the right to have Ms. Calloway there by your side so the two of you can confer in private. Do you waive your right to have Ms. Calloway by your side while we take this plea?
Yes, sir.
We are able to facilitate a conversation between you and Ms. Calloway. If something comes up and you absolutely positively need to talk to her in private, we can move the two of you to a virtual conference room. I won't be able to hear it. No one will be able to hear it or see it. You guys can speak privately. If you feel that need, let me know and we'll get you in that private room, okay?
Okay.
All right. Ms. Calloway, anything else before we start?
No, Your Honor.
All right, when you're ready, Ms. Chan.
Mr. Williams, can you please raise your right hand? I don't know if I can see Mr. Williams.
I can see him and his right hand is up.
Thank you. Mr. Williams, do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you state your true, correct, and legal name?
John Benjamin William III.
Okay. And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
Mr. Williams, you could put your hand down. How old are you and how far have you gone in school?
I'm 31 years old and I complete 12th grade.
Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the offense of aggravated assault?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charge in this indictment, including individual defense? Okay. Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Do you waive formal reading of the indictment, Ms. Calloway?
Yes.
And do you waive any and all defects in the indictment, counsel?
Yes. Mm-hmm.
All right. And back to Mr. Williams. Are you willing to proceed on a copy of the indictment, Mr. Williams?
Yes, ma'am.
Okay. Has your attorney advised you, Mr. Williams, of the minimum and maximum sentence for the charge you're pleading to For the aggravated assault, it's 1 year to 20 years. Do you understand that, sir?
Yes, ma'am.
Okay. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years, serve 1 year, commuted to time served with a balance on probation, and to have no contact with Ian Porter? Do you understand the court actually does not have to accept that recommendation, Mr. Williams?
Yes, ma'am.
All right, okay, and that he can, and the court can send you to maximum on that charge. Do you understand that, sir?
Yes, ma'am.
All right. And do you understand that this plea may be used to enhance sentencing on any other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that you are currently on probation or parole? Your probation or parole may be revoked based on your entering a guilty plea today.
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Hey, Mr. There you go. You had disappeared from the screen, Mr. Williams. Can you lean back a little bit? There we go. Great, thank you.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that neither the court, your attorney, nor the district's attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that, sir?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, that's 1 year to 5 years, or use a firearm in a crime that's 15 years consecutive, you would be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that, sir?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
You breaking up? I can hear you.
Hold on one sec. Can you guys hold off on the tape? It's just the weird background noise it's making is interrupting from the jail. This is my last case, and then you guys have the courtroom. It's going to Judge Farmer. Thanks. Okay. So they're putting some things in the courtroom to help indicate how far apart people need to be when we get people back in the courtroom. So my apologies, Ms. Chan.
All right, thank you, sir. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Okay, is your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of aggravated assault in indictment number 19-SC-173240?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Okay. Judge, had this case gone to trial, the state would have had a Ian Porter, who he would have testified that on September the 20th of 2019 at approximately 7 a.m., he was traveling on Martin Luther King Jr. Boulevard or Martin Luther King Jr. Drive near Bolton Road in Fulton County when the driver of another vehicle pulled out abruptly in front of him, almost causing an accident. At the next intersection, the driver stopped short of the light, and Mr. Porter was in the next lane. Verbal altercation ensued. After a verbal exchange, Mr. Porter was said that the driver pulled out a pistol and fired a shot into his own vehicle. At that point, Mr. Porter, in fear for his life, sped away. When the light turned, he veered off into a left direction. And when he got to work, he called police. Because Mr. Porter was recording you on his dash cam or some sort of dash camera at the time, police were able to pull the driver's license of the shooter's vehicle. They traced it to a woman who identified the driver of the vehicle at the time as the defendant, who was the father of her child or her children. Mr. Porter was able to get his vehicle fixed, and it cost a $500 deductible, which I understand that Mr. Williams has since made whole. That money was exchanged and given to Mr. Williams at the time, or was given to Mr. Porter. Mr. Williams' history indicates that he has no prior felonies, but there have been a bunch of misdemeanors. In 2006, he did a first offender already, where he had been charged with purchase, possession, manufacture, distribution, sale of marijuana. He was given first offender for marijuana possession and possession of MDMA. He completed that. His subsequent convictions, again, are all misdemeanors, such as obstruction, criminal trespass, simple battery out of Cobb in 2010. 2011, simple possession of marijuana out of Cobb. A 2012 DUI out of Douglas County. And in 2015, traffic violations such as driving on suspended license, failing to obey the traffic sign. And that is all the history that we have.
Okay. And tell me, have you talked to Mr. Porter about the fact that you are recommending that Mr. Williams serve barely more than 2 months for firing a gun at him?
I did talk to Mr. Porter, and that is, and part of the agreement, part of what Mr. Porter was satisfied is, we believe this is strangers, you know, because this was a traffic incident. Mr. Porter is satisfied. Originally, it would have been 10 years served 1 year, but because Mr. Williams was able to make him financially whole again, we agreed, and Mr. Porter was on board as well for commuting this to time served.
Okay. All right. Ms. Calloway?
Yes, Your Honor, we would ask the court to accept the state's recommendation as negotiated. Mr. Williams is a father of 9 children, 4 of whom live with him currently, and he's financially responsible for all 9 children. On the day of the incident, he had 3 of the children in the car with him and was headed to take them to school. And he, like the state said, there was a verbal altercation that started with the alleged victim, in this case, Mr. Porter, and he admitted that he rolled his window down and yelled obscenities, and Mr. Williams did take the altercation to the next level by firing a firearm, and it's his contention that he was doing it to defend his children. But he does understand the shooting of the firearm took the verbal altercation to a physical one, and he understands how dangerous it was in doing that. And he also, like the state said, went ahead and paid the $500 deductible to Mr. Porter in exchange for this recommendation. And we would and he also has a job. He has been gainfully employed at General Wholesale for a few years now, and his job is waiting for him upon his release. And so we would just ask that the court accept the state's recommendation as negotiated.
Okay. So I don't know how Judge Cox does things. I don't want to upset that apple cart. In my division, someone who attempts to enter a plea this early on in the proceedings has the ability to withdraw that plea if the judge sentences in a manner that is inconsistent with what was negotiated. How does it work with Judge Cox, Ms. Calloway?
I believe that Judge Cox operates in the same way. I have not been in his courtroom as much. Maybe the state can speak more to that.
Okay, Ms. Chan, what's your understanding of how that works?
I wish I knew, Judge, because I've only been assigned to Judge Cox when this pandemic began. So I have never, formally done, I don't have a history with Judge Cox, so I could not speak to that.
All right. Well, I will exercise my discretion and let you know, Mr. Williams, that because I'm the one taking the plea, you have the ability to say no thanks after we talk a little bit more about what I think is an appropriate sentence in light of what happened on September 20th of last year. You with a car full of kids and a guy who mouthed off at you. But I do find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Knowing means you've understood all the many things Ms. Chan asked you about. Is that a fair statement?
Yes, sir.
Do you have any questions about anything Ms. Chan has said so far or anything I've said?
No, sir.
Okay. Voluntary means just what it sounds like. You're entering this plea because you think it's in your best interest. No one's forced you to do it or promised you anything other than the recommendation that was made. Is that a true statement?
Yes, sir.
Okay, well then I will accept your plea. I am sentencing you pursuant to the Probation Options Management Act. That means that for the probated portion of your sentence, if you have a technical violation of probation, you miss a meeting, or maybe you have one positive test for a controlled substance, you don't need to get back in front of a judge. You would work that out with probation. But if it's something more serious, a new arrest, something like that, that would get you back in front of Judge Cox. This will remain his case. It doesn't become mine just because I'm taking the plea. That said, Mr. Williams, I will tell you that I am surprised that the state believes that the mere fact that you paid some restitution makes this a time-served case. You could have killed someone. Your kids could have been killed. You pull a gun on this guy, he pulls a bigger gun, you're dead, your 3 kids are dead. You could have hit someone who wasn't the guy in the car next to you. There is no justification for what happened. I didn't hear anyone say, well, actually, I ducked, he shot first, and then I fired back. Still not a good situation. But the judgment that it sounds like you showed by pulling out a loaded gun with 3 kids in the car and firing at a complete stranger, because what? Because he said some things you didn't like after you cut him off? That is totally out of line. And the way you're going to internalize that is by spending a little more time in custody. And I appreciate you've got kids and you've got a job, but apparently that wasn't top of mind when you drew down on this guy and pulled the trigger on a loaded gun at a crowded intersection and you hit his car. We are all grateful that that's all you hit. We are all grateful that the 3 kids you were driving are still okay. But what you did was illegal, stupid, and it's going to have some pretty serious consequences if the case stays with me. I'm going to sentence you to 5 years to serve 1 year with a balance probated. You would get credit for the time you've been in, but you're going to serve a year. You're welcome to take that sentence, you're also welcome, as I said up front, to say, I don't think so. There's more to this case, and I will wait it out and let my attorney litigate it further. There's some motions I'd like her to file, etc. If you want closure today, you'll have the certainty that the sentence is 5 years to serve 1 year with the balance probated, no contact with Mr. Porter. But I will respect it if you say, no thanks, Judge, that is not what I had signed up for. If you want some time to talk with Ms. Calloway, we can put you in that room of privacy so you guys can talk. You understand what sentence I would impose?
Yes, I understand, but I would like to talk to Ms. Calloway.
Great. I don't know who our special operator is, but one of these boxes on here is able to move 4 North and Bianca Calloway to a breakout room. I think that must be FC trial calendar. Can you make that happen?
Good morning, Judge McBurney. Ms. Pineda here. Yes, 1 second.
Great. Thank you, Ms. Pineda.
You're welcome.
Actually, if I may make a suggestion, instead of moving it over to my trial calendar, it's my suggestion that we keep it on yours, Judge McBurney, for just solely because the calendar was published as your calendar. And if someone was going to come in trying to find one of their family members, or just the public wanted to see the calendar, it was published as yours. So they would click, they would look for you on the website.
So all I asked was to have Mr. Williams and his lawyer move to a private room so they could have a private discussion. I didn't say anything else.
Oh, okay. I'm sorry. I was looking at
You were multitasking. Why don't you go off video and return to your multitasking? Thank you very much. We'll see you shortly.
Okay.
All right, looks like Mr. Williams made it. Ms. Calloway hasn't made it yet.
Okay, I got the notification.
Great. Well, I will take this time, and we're not on the record, Mr. Forte, because of course, Mr. Williams isn't here. I just want to thank all the good folks at the Sheriff's Office for making this work so smoothly. I know we took a few things out of order, and you guys rolled with it. So thank you for doing that and making this as smooth as possible. You guys are doing good work over on the jail side.
I know. I don't know. Well, let me know, Kiana. It's not like
Ms.
I have
Pineda,
much.
you're not muted.
Okay.
Thank you. All right, I'm going to mute till our two friends return. Ms. Pineda, do the people in the breakout room have a way of letting you know they're done, or they have to leave it on their own, and that's the only way we know they're done?
Yes, they have to come back into this chat room with us.
Okay.
Mhm.
And did the notification alert them to that fact that when they're done, click here, or do we run
No,
the
it has
risk?
it has a button to leave the room.
Okay.
Yes, it does.
All right.
And in order for me to get any sort of message out to them, I would have to join the room with them.
Okay. I'm
Yes.
not rushing them. We'll give them a few more minutes, but then we may have you drop them a message making sure that they know how to get back in.
Okay. Okay.
Thanks.
You're welcome.
Mr. Forte, are you ready to go back on the record? Okay. Mr. Williams, did you have enough time to speak with your lawyer, Ms. Calloway, in the private breakout room?
Yes, sir.
Okay, Ms. Calloway, did you have enough time to speak with Mr. Williams?
Yes, Your Honor, and we would ask, and we just want to clarify if we can, instead of the 5 years to serve one, can we word it as 5 years to serve 12 months so that he can finish his time at the county jail? As I understand it, they won't send him, they're not transferring inmates anyway, so they won't send him to a state prison because of the virus right now. So if we just write it as 12 months, he can finish his time within the Fulton County Jail.
So I understand the request.
Yes.
Two things. One, I believe as early as next week, Department of Corrections will begin transporting defendants again. They have built the capacity to do that. They obviously won't all come from Fulton. There's a statewide backlog, but they are beginning to do that. And second, I understand the nature of the request, but as a felony, I don't think that's a proper sentence. Because if I were saying 6 months, I could say 6 months, but it's a year. So that's the sentence that I think is appropriate. / Department of Corrections, as early as next week, will begin moving people again. Whether Mr. Williams, he wouldn't be at the front of that line. There is some pent up backlog, and they're going to start with the folks who've been waiting the longest. But that's where we are now. It may be, this has happened before, given that Mr. Williams has been in for a while, they say it's not worth it to transport him. And if they let the sheriff know that, the sheriff will do what he sees fit in terms of the way the sentence plays out. But I never get in the middle of those things. I know some people say, hey, you can get 2 for 1, things like that. Maybe, maybe not. That to me is more tea leaf reading than anything else. But I shared with Mr. Williams what I felt was the reasonable and appropriate sentence in light of everything I heard from Ms. Chan and from you. And he can go forward with that, knowing that's the certainty, and get credit for the time he's been in. Or, as I said, I'll respect fully his decision to say, you know what, I think I'm going to approach this from a different angle.
Yes, Your Honor.
So what did he decide he wants to do?
He wants to go forward with the court's recommendation.
Okay. What I need to do is sign the indictment for each of the 3 participants to this discussion. That would be Mr. Williams, that would be Ms. Calloway, that would be Ms. Chan. And I'll start with the state. Ms. Chan, do you authorize me to sign the indictment on your behalf?
Yes, sir.
Okay. Ms. Calloway, do you authorize me to sign the indictment on your behalf?
Yes, Your Honor.
Mr. Williams, to complete the plea, you normally would sign the indictment and put your signature there. You can't do it because you're there. I'm here. Do you authorize me to affix your signature to the indictment indicating that you're entering a plea to this case?
Yes, sir.
Okay, I will do that. We'll get that out the door today. Mr. Williams, I wish you the best as you move forward. You've got a lot on your plate, a lot of kids, and I know you want to get back there and help them out. It's important you understand going forward, you will be a convicted felon. So in some ways, this will be a simpler situation in the future if you run into someone who isn't treating you right on the roads. You cannot have a firearm anymore. So you'll just have to give them the finger or something else. But it's important for your safety, and more importantly, the safety of your many valuable kids, that you handle a situation like that in the future in a real different way. Ms. Chan, anything else from the state in Mr. Williams's case?
Just to make sure, Your Honor, is including the no contact with Ian Porter.
That'll be in there. It sounds like it's stranger on stranger. That should be the easiest part of the situation. I'll also add this, and I should have mentioned it before. Mr. Williams, I will waive the supervision fees for the first 3 months of your probation. As you get back on your feet, whether you're able to go back to the job you've got or you find something else to do, I know it sometimes takes a minute, and the last thing you need is to be paying a supervision fee. So I will waive that supervision fee for the first 3 months. Ms. Calloway, anything else on behalf of Mr. Williams?
No, Your Honor.
Okay, everyone have a good weekend. Thank you.
Thank you.
Excuse, Your Honor. That concludes my business. May I be excused, Your Honor?
Yes, ma'am.
Thank you.
And I'm going to transition. You can see his handsome face on the screen right now to Judge Farmer. The remaining cases are his. It's a large number of cases, but I noticed a bunch of them are the same people with multiple cases. And they will be bond hearings, as far as I can tell. But Judge Farmer is going to manage that. His litigation manager has joined us, so mine will be signing off. Thank you, Ms. Nelson, for your help. And I will sign off in just a minute. As Judge Farmer noticed, this calendar is published under my name. So if any of the lawyers have family members of clients or victims who want to follow the proceedings, they should continue to look to the McBurney link for the live feed. The Farmer link is going to be dark. So with that, thank you, Judge Farmer, for handling your matters.
Yep. I'm going to borrow your court reporter, though.
Oh, right. Mr. Forte, you're on for the duration. You okay with that? The thumbs up.
We've been
discussing.
discussing.
Good work, Mr. Judge Farmer. Treat him well.
Goodbye, everyone. This is Deidre signing off. Goodbye.
Bye, Ms. Nelson. Thank you, Ms. Pineda, for serving as the technical engineer.
You're welcome, sir. Anytime. My pleasure.
All right. Bye-bye.
Okay, I see I have my public defender. I have probation. Well, I had probation. Where'd Mr. Allen go?
Right here, Judge.
There, he's still there. Okay.
Judge Farmer?
Yes.
I'm assuming we're still going to stay on Judge McBurney's channel?
Yes, ma'am.
Okay. Thank you.
And I see we've got 6 South. So who do we have out of the jail?
We have position number 9. He's actually position 9, 10, 11, and 12. We would like to waive sounding on position 9. Waive sounding.
And your elder?
This is Mr. Elder?
Yes, sir.
Okay. And he's positions 9, 10, 11, and 12. Okay.
Is there a particular order, Your Honor, that we're going to follow for these? I've got position 7 and 8.
Okay. Well, Mr. Eddings, here's how it's going to go. The jail is the people that are actually they're the folks that actually got to move folks around.
Gotcha.
So I kind of defer to them.
Okay.
And as they get their people, they're the ones that actually have to, like I said,
The way we have it right now, Judge, we will be doing positions 9 through 12 first. 3 and 4 will be after those, and then positions 7 and 8, and then we will jump down to 5 and 6, if I'm not mistaken.
Okay, and Mr. Eddings, you have 7 and 8. That's not Miss Ulrich.
Yes, Your Honor, I have 7 and 8.
Okay.
We did a substitution of counsel on the record. When we filed a notice, we did a substitution of counsel. I think I emailed Ms. Ulrich about that.
Okay. All right. I've made note on my calendar, so.
Thank you, Judge.
Yep. Okay, so let's start with Mr. Elder. Okay. These position 9 is 17 SC 156115. Position 10 is 16 SC 142826. Position 11 is 17 SC 151743. And position 12 is 17 SC 156418. Mr. Elder is represented by Miss Anna Ulrich in all these cases. Mr. Jenkins, do you have all these cases? Because I see that position 9 may be a CWAC case.
It is a CWAC case, Your Honor. I don't know why Kelsey wasn't on the email, but I mean, I don't think that I can sit in for her. I don't know what the resident issues are, but if you want me to give her a call and see if she can get on this calendar.
If you'll mute yourself and give her a call while I talk to Mr. Elder here.
I will do that, Judge.
Okay, Mr. Elder.
Yes, sir.
You have the right to be in open court for these proceedings. You understand that?
Yes, sir.
Okay. However, due to the current public health crisis, we are proceeding via Zoom or video conference. Do you have any objection to proceeding via video conference?
No, sir.
And do you waive any and all objections to appearing in open court?
Sir.
I'm sorry,
No,
Mr.
sir.
Okay, thank you. And have you had the opportunity to speak with your attorney prior to this hearing?
Yes, sir.
Okay. All right. And Ms. Ulrich, this is a bond hearing on all 4 cases?
No, it's just a bond. I'm not sure why they calendared all 4, but it's just a bond hearing on the 17 SC, the case on which sounding was waived.
Okay, 17 SC. We've got 2 17 SCs. Which one are we talking about here?
Let me just, I'm just pulling it up on Odyssey, Judge.
Mr. Jenkins, I don't think we need, the bond hearing is only on one of your cases. We don't need Ms. Jones-Connor, I don't think.
I don't believe so, Judge. I believe it's only on Ms. Jones-Connor's case.
It's, wait, it's only on Ms. Jones-Connor's case?
Docket ending 115. I believe.
Yep. Yeah, he's got 3 17 cases.
So yes, it's only on the one that is Ms. Jones, docket 17 SC 156115. That's the bond, the relevant bond,
Okay.
which is currently set at 25,000 with a 10%.
Okay. Well, I'm about to, Mr. Jenkins may be about to be a body with a bar card, much to his dismay. All right.
Because this case has been in a trial posture for quite some time, I do believe Mr. Jenkins is pretty familiar with it as far as being familiar with CWAC cases goes in light of the overlap, but obviously I'll let him speak for himself in that regard.
Mr. Jenkins, are you prepared to proceed?
Judge, my victim advocate is right now contacting Kelsey, so at least give her a chance to get on if you want to. I mean, if not, I'm a representative of the state, but
well,
if there's nothing unique.
We're going to push on, and if she jumps in,
all right, no problem.
I'll let Miss Ulrich have her piece, and then I mean, I can, from my end, I can look at criminal history and all that kind of good stuff. So, Miss Ulrich, you can proceed.
Forgive me, Judge. That is my Google Voice number, which clients have, and that's it's ringing on my computer. Let me just shut it down so that doesn't happen again.
Okay.
I'm back. So yes, I am asking that you grant Mr. Elder a signature bond either through pretrial services or through the jail. I do understand that that is, given the allegations in the case and the number of cases, would normally be sort of an unusual request, but we are in unusual times, and the circumstances to his case in particular, I think, warrant that. The instant matter, he was, Your Honor will note, granted a bond despite the presence of the other 3 cases, one of which is a mere possession case. The other 2 involve allegations of family violence battery, which would have been a misdemeanor, but for one prior conviction. Mr. Elder has been incarcerated for the better part of 3 years. My internet just went out, which is very frustrating. I'm sorry. I think I can do the majority of what I need without Odyssey, but that's why
I've got Odyssey up.
You know you do. So I guess just in terms of Ayala, let me deal with that, and then I can deal with the sort of exceptional circumstances right now due to COVID and Mr. Elder's health. I have spoken with a number of his contacts here in Atlanta that indicate that he will come to court, that he has a place to live, that he has employment, and that he will have no contact with the complainant, with whom he hasn't had contact in quite some time. I've been in touch, let me start there actually, in terms of any risk to reoffend or any future contact. I've spoken with the complainant on 3 different occasions within the last 6 months. She's indicated that she's had no contact with Mr. Elder, doesn't want any contact with Mr. Elder. He's indicated the same. He has not been reaching out to her, has no intention or desire to reach out to her. They are not in a relationship, have not been
Kelsey,
in a relationship.
you have a bond hearing in connection with
George, mute yourself.
Okay.
She also relevantly, just in terms of, I guess, the cases and how they may or may not proceed, there's been a long tumultuous history that, ends years ago, but between these 2 parties, and the complainant in the instant matter did call my predecessor on the case and deny the allegation, say that she made up the current allegations, that she was angry and her husband was coming home. There are a lot of reasons that were given, but that she did fabricate the allegations, the assault allegations against my client. So I spoke with his employer, Ishmael Jones, who owns Exclusive Lawn Care and Exclusive Fitness. Exclusive Fitness is in East Point. Exclusive Lawn Care has a contract with Fulton County as well as with Atlanta City. Mr. Jones indicates that Mr. Elder is one of his best employees. He'd been working for him for a very long time. He's never known him to exhibit any concerning behavior, violence. He shows up on time. He performs as he should. He does landscaping and painting. He was familiar enough with Mr. Elder. They're not friends. This is not a personal relationship. It is a purely professional. I did ask, sort of kind of trying to figure out, is this just someone who's vouching for him because he's his buddy? But that is not the case. Ishmael does not have a criminal history or any criminal contacts as far as I could tell or find. He was familiar that Mr. Elder had children and his 3 grandchildren as well. I've spoken as well to Mr. Elder's sister and his mother. He would be going to live with his mother, whose name is Garney Yarborough. I can provide that address if needed. So that's just in terms of Ayala. He has close community ties, every interest in addressing this matter, particularly given the complainant's denial of the allegations. He would want to show up to court to answer for these allegations, which he denies, and in fact, she has denied. I do understand the other 2 matters involving her are pending. They're very different in their tenor. And as I said, I think we're in a different situation now than we were. And in terms of what the time that Mr. Elder would be facing on those cases, he has served a large portion of any time that he were to get, even if—
On a rape charge?
No, on the other 2 allegations, on the battery charges. Okay. I just mean to the extent that the fact of those other cases pending may affect Your Honor's bond determination on the rape case, that our position is that the rape case will go away. I understand, obviously, we can't know that. We don't have a crystal ball, but those allegations have, for many reasons, been, we believe that they're false. So,
well,
yeah, I'm happy to answer questions that Your Honor has. I'm not sure what specifically you want to address.
What's his criminal history? Let's see. Just here.
He has a prior family violence judge from 2009, not with the same complainant, but it is.
And the 2 family violence batteries that are pending against him, are those the same complainant?
They are. That was all in fairly short order, all with the same woman. And I have reason to believe that, but actually a number of people, my predecessor, Mr. Budensky, as well as myself, have reason to believe that she fabricated those allegations. I believe she also told the then district attorney on the case, whose name I need to find, that it was not, that the allegations were not true as well. Her husband, during the pendency of Mr. Elder's relationship with this complainant, her husband was serving a probation violation for a rape charge in Alabama. And so he was returning home, and that is believed to be the motivation for the allegations.
Mr. Jenkins?
Well, Judge, we request that you deny defense counsel's motion for the following reasons. Number one, he does have 4 felony cases pending, for one of which is a rape case, which, depending on what the facts, is a mandatory minimum of, I believe, 25 years with a maximum of life, potentially without the possibility of parole. And so I think that makes him with that much time looming over him, depending on what the circumstances are, these cases are active, makes him a flight risk in connection with these cases. It would be essentially life without parole plus potentially
how many prior convictions does he have?
And he does have 4 felony convictions in his past, Judge. A aggravated assault in Fulton County from June 3rd of 1993. He has a 2007 conviction for drugs in Cobb County. He does have obviously the former prior family violence battery here in Fulton County, 2009, and it looks like some form of transporting something into a facility here in Fulton County, in 2014 conviction. It's 14 SC 124-991. So he has 4 pending cases and 4 prior convictions, Judge. And so I don't believe he's a good candidate for trial at this time. In addition to when these allegations arose, he's likely to commit another felony if he's released.
All right, I'm looking. He's got an 2009 conviction on the family violence battery.
Do you want the case number for the 14 case, Judge?
Oh, I'm looking at it right now.
And good morning, Judge. Kelsey Jones-Connor is here. I apologize. I was not on the invite for the Zoom, so I did not know it was happening, but luckily I was told. And I just wanted to add to Mr. Jenkins' statement. We do have 6 felony convictions for Mr. Elder. There's 2 Z cases, a Z16922, which is a drug case, and a Z54274, which is an aggravated assault in connection to the felonies that he listed as well.
Those cases are from the early 90s, is that correct? Well, I think one is the late 80s and one is the early 90s.
One's 1990, one's 1993. Then he has one in 2004, 2007, 2009, and 2014. And so looking at that, he is an A and C recidivist. And so in the rape case that we have, he would be looking at life without the possibility of parole.
Okay, here's the 14 case. So he's got a bond already, is what I'm hearing.
He does, Judge. Yes. Part of the reason that I actually filed this motion, it was coterminous with the habeas that had been filed by my office. We take the position, we still take the position, which I think applies specifically to Mr. Elder, that someone has made the determination here that a bond was appropriate, that it, notwithstanding his other cases and his record, that he's not a risk to not come back to court or to reoffend, such that no bond was appropriate. And given the current pandemic, Mr. Elder is almost 50. He is not in great health in terms of having high blood pressure, which I'm sure Your Honor knows, the large percentage of folks who are getting very ill are those with other pre-existing conditions. And so it's for those reasons that I am asking for a lowered bond. He cannot make the current bond. I've been in touch with his family. Obviously, if he could have, he would have done it at any time in the last 2 years since it was set. And the bond was set at a time when the then judge did know about the other cases. I will, I guess, just note finally that this has been on the trial calendar, I think at least 3 times since I've been the assigned attorney. I've answered ready. Every time the state has attempted to answer not ready twice. I realize we're in a weird limbo period right now, but to the extent that the state's unreadiness factors into bonds, I would like that to be considered. This was listed on a short list a couple times.
Because I didn't let them answer not ready, right?
Correct.
So the state's ready.
The state is ready, Your Honor, and that was something that we discussed. I think that was my first day in the courtroom, but once I had a chance to look at the case and knew the age of it, I mean, the state is ready, Your Honor. So I understand, and I do understand this is something that we do need to have at the top of the list because of the amount of time Mr. Elder has been in custody, but him being in custody, the state would argue is appropriate with the number of cases that he has, his history, and the time he's looking at.
While I understand, we live in trying times, or unfortunately not trying times because we can't get a trial. But even given the current situation, given the fact that he's got 6 prior convictions, however old, you're going to say they're old. The state's going to say that makes him a career offender because he keeps doing it. This is on a short list. It's going to go as soon as we can get rolling. I think he's got a bond. I think he's, I don't see any reason to lower the bond, Ms. Ulrich. I'm sorry. I'm going to deny your motion.
Thank you, Your Honor. And again, apologies for my tardiness this morning.
It's you're fine. No offense taken. Okay. So that takes care of 9, 10, 11, and 12. That's nice. Okay, and I think I heard from the jail that we were going to do 3 and 4 next.
Yes, sir.
All right.
Okay, and that is Mr. Marshall.
It is, Judge, but I just would request if we can, before Your Honor does the whole warning, that we may want to just briefly discuss that up front. I did send an email to Ms. Mejia about this case, which is which may not need to be heard this morning. So I just wanted to address that when Your Honor has a moment.
Okay, so what do you want me to do ahead of time?
Well, just have a brief discussion before we launch into the actual preparation for a plea or a bond hearing, just to know what we're doing. I emailed the DA, the district attorneys, and Ms. Mejia earlier in the week to let them know that we've had some delay in terms of paying for the program that would be a condition of a non-negotiated plea that had been previously discussed. And so I don't want to waste the court or anyone else's time if that delay is going to preclude resolution today.
Yeah, Mr. Marshall, this is the 8th Amendment argument you were mad at me about, right?
No, it's not even that. This is actually just the, oh, well, yes, this is that case, Judge. Yes.
That case. Okay.
Correct.
Yeah. Yeah, if you don't have someone for him to potentially go, well, I mean,
I do actually have somewhere for him to potentially go. He's been accepted. The dad is just gotten back to work, and there's a amount of money he needs to be able to offer in order for Mr. Marshall to enroll in the program. He will have that in June. I've spoken to the head of the program about it. I've confirmed with the dad in writing and on the phone that that's going to happen. So if Your Honor wants to make the program a condition of probation and understand he would not start until June, we could do that. But I also understand that may not be something the court wants to do. So I just wanted to at least be transparent that he would not be able to start with the program until June, when his dad's able to actually pay the money. Because this is
Have you had a chance to talk to Mr. Marshall about my thoughts regarding removal?
No.
You might want to do that. And what's the state's offer on this one, Mr. Jenkins?
Well, in my case, it is 3 to serve 1 year, balance probated, obviously no contact. And I did receive some information in connection with the potential restitution. And so I'll, 60 days to file a restitution motion for potential hearing. And
Mr.
no
Petty?
further violations of the law.
And Mr. Petty, what was yours?
Your Honor, mine is 10-3, special conditions, no gangs, social media, things of that nature.
Okay.
And I had requested 5 serve 1, Your Honor, with a release to this program, Next Level Boys Academy. Obviously, I can put on the record all the reasons, but that was the landscape.
Okay.
That's under first offender, to be clear.
2 cases.
Correct. That's correct.
So you're also asking you'd be asking me to consolidate
For purposes of the sentencing, yes, Judge.
for trial and sentence.
And Your Honor, on my case, mine is the second in time. I would object to those being consolidated for the state.
Fair enough. There's only one arrest in association with this case, correct?
That's correct.
Okay. Because they happened pretty close in time, didn't they?
June 2018 and then April 2019.
Actually, I don't know if there was. I think I might have misspoken, Judge. Let me just see. Do you guys know?
No, he was out on bond on one when he got the second one.
Yeah, no, that's
Mine from
there were 2 arrests.
June 18.
Yeah. Miss Ulrich,
Yeah.
we can do this. We can do this as a later date if you want. But I don't know. I don't know that it's going to help you or your client.
I mean, what we had discussed, Judge, is we were prepared to proceed.
Okay, no, he's got to be ready to go in. We need to. Here's the thing. Starting on the Tuesday after Memorial Day, we are going to start having each judge is going to get to do their own cases. We're going to get half days. We're going to be limited to 6 inmates, and that will start rolling. So basically, we will be able to have court once every 7.5 days because there are 15 judges hearing criminal cases.
Is that via Zoom or in court? Actual court?
It's via Zoom until the judicial emergency expires. And the reason it's limited to 6 is because it's my understanding that the sheriff is going to only bring over 6 per courtroom to try and maintain appropriate distancing amongst the inmates.
Right.
But until they start bringing folks over, it'll still be via video conference. So, Mr. Marshall, it's not going to be another 3 months before he hits the calendar again.
Okay. And that was the only reason I didn't even ask for him to be completely pulled, is that I didn't know how long we'd be waiting and didn't want to risk that. But I also understand and respect that the court wants the program in place, and it is in place. It's just a financial issue right now. But
Okay.
his dad has been in close communication, and the head of the program, Mr. Davis, the head of the program, understands that he's good for the money. He has employment. It's just a matter of getting his bills paid as well.
Well, he's gonna sit because that's an inpatient program, right? It's
not, but there's a lot of supervision. This is the Next Level Boys Academy, where he has a mentor assigned.
Well, here's the thing, Miss Ulrich, before we do this, you need to talk to him.
Of course, we've had a lot of trouble.
You need to talk to him about what you and I talked about,
Yes.
because I'm going to do that. You need to talk to him about that. So we'll handle his business later.
Okay.
All right.
Okay.
Is that a reset, Judge?
Yes, sir. Thank you.
Your Honor, this is Petty. That does conclude my business. Can I be excused?
No.
You and your quarantine beard can move it on down the road.
Thank you. Judge, I was expecting to see more from you. I'm kind of saddened I don't see the Christmas beard.
It's not Christmas, it's May. No, I do that in the winter time. Watch me during hunting season, you'll see it.
Fair enough, fair enough. You all have a good day.
All right, Adam, take care, man.
All right.
All right, what we got? Who's up next?
So I think,
Mr. Liggins.
all right,
Oh, okay.
Mr. Eddings, you jumped on up. You can unmute now. We're going to positions 7 and 8. So, Mr. Eddings, you can take yourself off mute. And do we have Mr. Liggins? Is this Mr. Liggins in 4 North?
Yes, sir.
Okay, I've got 2 North on my calendar. That's what threw me off. Before we begin, Mr. Eddings, you're still on mute. Are you ready to proceed? I see you moving around.
Boy.
Yeah, can't hear you.
I'm not able to unmute him, Judge. Let me see.
Can't hear you.
Got him.
I got it, Judge.
There we go.
There you go.
Okay. Okay.
Is everything working now, Judge?
Yep. All right. Okay, so we have Mr. Liggins, position 7 and 8. Before we begin, Mr. Liggins, I want to talk to you about the fact that you understand that we're here on a bond hearing for you today. Your attorney has filed a bond motion for you, and you have the right to be present in open court. Do you understand that? Okay, you need to answer out loud so the court reports.
Yes, sir.
Okay. However, given the current health situation going around the country and the world, we are proceeding via video conference.
Yes, sir.
Do you have any objection to proceeding via video conference?
No, sir.
And are you willing to waive your physical presence in open court and go and continue with this hearing?
Yes, sir.
Okay. Then Mr. Eddings, do you have any objections to proceeding via video conference?
No objections, Your Honor.
Mr. Jenkins?
No objection, Your Honor.
Okay, thank you all very much. Mr. Liggins has 2 cases, 20 SC 174-802 and 20 SC 174-927. It appears he was booked on the same day for both these cases, but we're here on his motion for bond filed by Mr. Eddings. So Mr. Eddings, I will let you proceed, sir.
Thank you, Judge. Good morning still. Good morning, Judge. Good morning, Mr. Jenkins. Good morning, Mr. Liggins. We're here on a motion for bond. Mr. Liggins has been incarcerated now for approximately 90, a little over 100 days for these particular charges. He doesn't have any bonds. Of course, these 2 have been indicted already. But, given COVID-19 and the situation going on, we're not sure what the state's posture is in terms of getting this case resolved via trial or otherwise. We feel it would be in his best interest to get a bond in this particular case so he can be released and prepared for a case in this bond. He's from Atlanta. He does have a prior history, Your Honor, but he doesn't have any violent history per se. And we feel that he's not a threat to any victim in this particular case. The charges are theft by taking and theft by shoplifting in the case ending in 802. And then he's also charged with theft by receiving a stolen property and possession of a firearm by convicted felon. That's in case ending in 4927. He was employed prior to his arrest. We don't see him being a flight risk. He did retain the funds to hire legal counsel for both of his cases, where I'll be representing him in both matters. He does have 2 other cases that it seems like are pending, but they're at magistrate court level, and they hadn't gone beyond the magistrate court level. they have CP case numbers assigned to them.
Well, I will say, before you go any further, Mr. Eddings, I'm looking and I see a warrant that was issued by Judge Douglas on May 6th of this year. It's a felony. It was signed, taken out of the North Annex. It was, like I said, issued on May 6th for an occurrence, theft by shoplifting, on January 26th of this year. And I see both incident dates. Well, I don't see the incident dates on these. He was arrested on the 29th. I don't know if that is an additional, because for some reason I can't. I'm trying to see the warrant and I can't, because that would help me know.
Yes, Judge. You know, I want to say that's the same case he was arrested on, but I can't say that with any certainty.
It was just issued May 6th, so.
Oh, it was May 6th, and he was in jail on May 6th. He's been in jail since January
29th, right? No,
29th.
it looks like the alleged incident date of the warrant that's outstanding is January 26th of 2020.
Okay.
Arresting agency.
Okay. We'll note that, Judge. For the record, as far as that warrant is concerned, obviously he's in custody now. I would imagine that warrant would be handled now that he's in jail custody of the Fulton County Jail.
Well, it hadn't been served on him yet, but.
Okay. Not sure. May 6th, today is the 15th. So I know with everything going on administratively with the COVID-19, it's probably a delay in getting that administered, but that would definitely bear some impact on his release on bond. But if we can still proceed with at least getting the bond set for the cases that we have before the court today, and then that would just put more work on my plate to figure out what's going on with the warrant that hadn't been served yet, and find out what the issue is with that.
Yeah. Okay.
With that, Judge, for these particular charges, Judge, we would ask for a reasonable bond in this particular case. He was employed. He was making just over, not quite even $10 an hour at his employment. So it doesn't have all that much money. His family had to help with his legal defense, paying his legal funds. We would ask for a bond on each of the charges if the court will accept a bond of $2,500 for each count. So in the case ending in 4802, that would be an aggregate of $5,000. And then in the next case, it would be another aggregate of $5,000. So a total bond amount that we're asking for today, not to exceed $10,000 for these particular charges, Judge.
Okay, and Mr. Jenkins?
Briefly, Judge, thank you, counsel. Good morning, Mayor, Honorable Court. George Jenkins, on behalf of the state. At this time, the state would request that you deny defense counsel's motion. The defendant is likely to reoffend if he were to be released. His status, he has 12 prior felony convictions, mostly for theft and drug-related matters. He does have a prior escape conviction here in Fulton County, 2007, and a couple of aggravated assault convictions from the early part of this century, one in 2002, one initially charged in 2002, but not pleading guilty until 2006. And so with his current issues, with his criminal history, he's just not a proper candidate at this time. We request you deny the motion. Thank you, Judge.
12 prior felonies?
12.
And an escape.
I don't see the escape on his record, Judge. I mean, I do acknowledge most of his charges have been theft in nature, dating back to 2013. There's one that was in Richland County in 2019. And then he's got, he does have the aggravated assault as being the worst as far as the most severe offense, but that's going back to 2002 and 2006. Most of his current history has all been death-related cases, Judge, and there's been a violation of a controlled substance charge. And I wouldn't be surprised if there's a connection between the substance abuse and the death by shoplifting that he's had in the past, in his previous experience.
I
also see
the escape conviction. I have the case number for it if you want it, Judge.
Okay, sure. Thank you, Mr. Jenkins. I'll take that.
That's 06 SC 49526. Conviction date is February 20, 2007.
Yep.
Mr. Jenkins, you wouldn't happen to know the details of that escape, do you?
No, bro.
Okay. All right.
He did enter a negotiated plea.
Yeah.
And that's just another factor, but you know, I can't tell you. But true, most of his, you know, property crimes and, you know, drugs and such, and so we understand that. And 2 charges he's facing right now are property crimes.
And I also see, here's another problem I see, is I also see bench warrants in his past.
Yes, Judge. The only thing we would say as a matter of defense, Judge, is that Mr. Liggins does have enjoyed the presumption of innocence on this on these particular current charges. Yes, while his prior history is a factor, Your Honor, we would ask if the court would weigh his presumption of innocence in this particular case and not use the prior offenses, things that he's definitely served his time for, and put himself in a position not to reoffend. He does have a defense for these particular cases. He hadn't had opportunity to put forth his defense yet. So, you know, given the fact that he did go to some financial length to hire counsel for these cases, and the family is intimately involved and behind him defending himself, I would say that they could afford an ankle monitoring system. Given his past history with the escape and the bench warrants, we can put him on a monitoring device and let him be monitored while he is released on bond. If the state would be inclined to grant a bond in this case, that he would be monitored the entire time and subject him to a curfew that keeps him indoors when he's not working. So if the state would consider those in light of his past history, and given the charges, you know, they're not, you know, any crime is bad. I'm not saying that anyone should commit any crime, but you know, these aren't armed robbery charges, aren't burglary. There's no victim here in these particular cases. So we're not talking about the violent type offenses. While they're inexcusable, they're not violent offenses, and we feel that he is a good candidate for bond, given the nature of these charges, with the proper special conditions of an ankle monitoring device as well as a curfew, because he does have a history, as pointed out by the state.
That's very well spoken, Mr. Eddings. However, I find he's a flight risk and a danger to reoffend, and I'm going to deny his bond.
Okay, thank you for the court's consideration, Judge. Mr. Jenkins, thank you, Mr. Jenkins. The only thing what I would ask Mr. Jenkins is if we can get the discovery over, could probably resolve this case sooner than later. Maybe not waiting for a grand jury to convene.
Well, because the other one, see, can you do the other ones maybe on accusations, Mr. Jenkins, and look into that? Let me give you the warrant number that I see is outstanding.
Okay, Judge.
Warrant number, hold on. It is.
I can't envision him getting a sentence, or at least from an offer from us, that's going to
No,
get him
look,
out of jail. So
That's for y'all to talk about.
right.
Uh, the warrant. Oh, no.
Yeah, if you have it.
Yeah, hold on one moment.
These cases originated out of non-complex, so
Right,
they'll be doing
and-
some searching for it.
And I'm sure any sentence would involve staying far away from Lenox Mall.
Yes.
EW
Or Fitz Plaza.
EW
0299-250.
Thank you,
All
Judge
right.
Farmer.
No, you did a fine job, Mr. Eddings, but 12 felonies.
Yes, sir.
Can't do it.
Yes, sir. We understand, Judge.
All right,
All
thank you.
right, I'm gonna work on that discovery, what I can find for you, no doubt about it, and we'll definitely talk.
Okay, Mr. Jenkins. Thank
All
you,
right,
sir.
counsel.
Mr. Liggins, I think you've heard everything. We just got to keep pressing forward for your defense, okay? Okay. Judge, that concludes my business for today. May I be excused, Your Honor?
Yes, you may. Thank you very much,
Okay.
sir.
Thank you, Judge.
Thank you. All righty. I think we're up for John Everett now.
This is our last case, I believe.
He's position 5 and 6.
Oh.
And I see, do we have Mr. Everett there in 2 North?
Yes, sir.
Okay, thank you very much, Sheriff. Mr. Everett, we are here on your attorney filed a motion for bond for you. And I want you to understand that you have the right to appear in open court. Do you understand that?
Yes, sir.
Okay, given the current health situation that's going around the world, we are today proceeding via video conference. You understand that?
Yep.
Are you willing to waive any objections to appearing in open court and consent to have your hearing via video conference?
Yes, this is cool.
Okay. Now, Ms. Ulrich, is that cool with you?
It is cool with me. Thank you, Judge.
Mr. Jenkins?
No objection, Judge.
All right, fantastic.
That was what I meant, to be clear. No objection.
I understand. All right. In that case, these are cases, positions 5 and 6 on the calendar. Position 5 is 19 SC 167851. And position 6 is 20 SC 174149. And Ms. Ulrich, it is your motion. So I'm going to let you take the lead.
Yes, just for the record, Judge, I just want to mention, I know Mr. Jenkins knows this, but I don't have any discovery on the 20 SC case. And which, of course, depending on what happens today, will be more or less pressing, but we do need that. I'm asking that Your Honor grant a bond to Mr. Everett, in particular, a signature bond through pretrial services. He does have 2 cases. I suspect I'll start bad and go to good. I suspect that the state will mention that he has 1 failure to appear and 1 probation violation. I would just note that those are both with respect to the instant case. The failure to, well, he has 2 cases. So he has a 19 SC 167851 and then the 20 SC case 174149. Mr. Everett was released on the 19 SC case. He did move between the time that he was released and the time that, well, actually, he returned to a different home when he was released than the address that he had given, because he struggles with drug addiction and he knew that going back to the address that he had given was a recipe for disaster. He went to stay with his mom in Covington, which is where he would return to stay if he were released. And that's the only failure to appear that I see on his history. I just note that it even says in Odyssey that he was released from the Fulton County Jail on bond before the court date was set. So I think he would have had to have gotten mailed notice to know about the court date. So at any rate, I don't believe that was an intentional, willful failure to come to court. Mr. Averett has no felony convictions whatsoever. He does have some misdemeanor history, driving on a suspended license, imitation controlled substance, and 2 theft, shoplifting misdemeanors. Between 2007 and 2018, he has been on and off the wagon with addiction. We are working to get him into drug court. The district attorney and I are going back and forth about that. But in the meantime, he would have support from River Edge Behavioral Health, which is an outpatient treatment program in Atlanta. That's what we have lined up for Mr. Averett, but there's also a program in Covington called New Rock, which I've been in communication with. Mr. Averett's nodding his head. His mom and I spoke about New Rock. He has never had any court mandated treatment or treatment mandated by bond. He has struggled with crack cocaine addiction since he was 15. He has had some periods of sobriety with some success, but often falls off the wagon and clearly needs some outside support. His mom indicates that whenever he's been living with her, he does well. And then what will happen is he'll come back into the city with her permission, not sneaking out or anything. I mean, he's a grown man, but will come back into the city and then fall off the wagon. So the setup would be that he would be living with her. Melanie Williams is her name. She's in Covington, and then attending River Edge until we're able to get something more formal set up with New Rock, and then ultimately, hopefully, resolve the case with a drug court resolution. The DA and I just aren't there yet. So in terms of Ayala, I do think I understand he does have the one failure to appear. I don't believe that was a willful or intentional not coming back to court. He does have the other case that he picked up while he was out. Mr. Averett does strenuously deny the trafficking allegations in that case. I don't have all the discovery, so I can't speak very specifically, but his denial is consistent with his record and with what my conversation was with his mother, which is that he is a user and not a dealer. I do believe that the allegations of the drugs were found in a car and that there were multiple individuals present. My client was not in the car at the time. So for all those reasons, I'd ask that Your Honor grant him a bond at the very least. I'm asking for a signature bond through pretrial services.
So is he in on a bench warrant as well?
Yeah, Judge, yes.
On the 19 case, there's a bench warrant.
There was one, yes, Judge. There was an FTE in that case, and that came up when he was arrested on the trafficking case. And I apologize to Anna. It looks like during this course of, I have a copy, my legal assistant, instead of filing this under 20 SC 174 149, she tried to file it under 19 SC 174 149, and the case doesn't exist. And so she put a copy of this discovery, and I'll get it to Anna. Basically, what the current case was is that the police got a suspicious vehicle call. The vehicle entered stolen, and the co-defendant, Mr. Bell and Mr. Everett, exited the vehicle when the police rolled up, and then they found the drugs in the car. And so that's the allegation in that case. And the other case is a theft-related case as well. And so, Judge, in this case, and I did note that there's, and I gave that information to Ms. Ulrich in terms of his priors. The state at this time, the court's discretion, will offer a bond in both of these matters in the following conditions, Judge. In the 19 SC 167851, the state would request 11,000 straight bond. That is 5,000 on each felony and 1,000 on the misdemeanor. And then in the 20 SC 174 149, the trafficking case, the state would request a $66,000 bond with the following breakdown: 25,000 on the methamphetamine, 5,000 on the heroin. I do believe there are 3 counts of identity fraud, 10,000 each on those. Theft by receiving, 5,000, and 1,000 on the marijuana charge, Judge.
For a total bond of 77,000?
Yeah, for both cases. And we're asking for straight, whatever you want to do with it, Judge. It's in your discretion.
Okay.
And I'm going to ahead and scan this to Anna and then get it filed correctly as soon as we're done. So look out for it, Anna, in terms of the trafficking case mean, it's not complicated. It's not a drug investigation. It's just a bunch of drugs in the car.
Gotcha. All right.
And it is our position, to the extent that anyone is going to claim this pharmacy, that it is not Mr. Averett's.
Right. Well,
And I mean to say that explicitly. Obviously, he's facing a lot of charges. He's presumed innocent in all of them, but I'm explicitly addressing that here to the extent that that factors into your honor's bond determination as 66,000. It's a total of, I guess, $77,000 bond would be tantamount to a remand for Mr. Averett. I realize we don't say that here, but tantamount to a no bond for Mr. Averett in terms of his parents are people of modest means. His mom may be able to make some very small amount of bond, but any cash bond will be a stretch for her. So that's a very high bond. And I don't believe this is a trafficking case. I'm so sorry.
Okay, he bench warranted. I'm looking at the bench warrant here, and I'll share this with you all. Okay, can y'all see the screen?
we can, Your Honor.
Okay.
Yeah.
This is the bench warrant.
Okay. Yeah. In the RSP case. Yeah.
Looks like he might have been down in non-complex. And this is the Glenwood Avenue address. So now we need to see whether or not notice went out for that guy. He missed in May. $722. Okay, it went to the Glenwood address. That was his address. Transfer. Got kicked up here. You know, folks that get in trouble when they're out on bond, I kind of frown on that. He skipped out on pretrial services? Okay, so this isn't, Ms. Ulrich, if you look at this, this isn't him missing the court date. This is him violating conditions of his pretrial release.
I think what happened, if I gotta go back and look, but the catch-all calendar, this would have been an APH. I don't gonna look at the bond order right now, but I don't believe that, I'm not sure it's clear that he was present in court when the bond was granted. Having been in non-complex, it happens not infrequently where the judge will grant a bond and then the person is then told what they have to do, but the message is conveyed not even by their attorney, but by the deputy or by someone at the jail. I'm just connecting to remote access so that I can get into Odyssey. My computer's been, but I'm not sure it's entirely clear that he was told that he needed to report to pretrial services.
Well, see that order for bond.
Exactly. I'm sure, yeah, since you're in, sorry to ask Your Honor to do that.
County bond order. Signature of defendant. Because I agree with you, Ms. Ulrich, that does happen. That's why we have defendants sign stuff.
Of course. And so you're looking at the one from the jail judge in the 19 SC case?
Mm-hmm. Yes.
Okay.
So
I see it. So, yeah, I just know that Mr. Averett doesn't have felony convictions and that he has had to come to court before. His mom also indicates, I mean, there was quite a long period of time from the time he got released until the time he picked up this new case.
right, and here's the thing. There's a lot of time between the time he got released and the time he got picked up. And during that time, he wasn't going to pretrial services either.
No, I mean, the reason I understood, Judge, although him being at the jail and being told, I guess.
No, he's not being told. He signed off on this. You can see level 1. That means you show up once a month to pretrial.
It is. I'm sure Your Honor knows the setup that happens at the jail, which is that he's handed someone from our office, a paralegal from our office takes this order back after the judge has spoken to both parties. A paralegal walks back and has him sign the order. And I'm just saying, I do think it happens not infrequently where it's not very clearly explained what exactly needs to happen. And I'm asking for just one more opportunity for him to be able to do this. This is not someone who's repeatedly not come back to court or who has had a long record.
First it was, hey, he didn't know about it. And that's true, because sometimes you see bond orders with no defendant signature on it, and that's true. Now, we say that he has signed for it. Well, maybe it didn't get explained well enough to him. I mean, unless you got somebody saying, you know what, I didn't tell him what to do. I mean, these terms are pretty clear. These terms are pretty clear.
Understood, Judge. I guess the reason I'm being so vague and sort of it's a moving target is because both of those things happen not infrequently. And I don't know, this is 2019, early-ish. I don't know which of the two it may have been, but I don't think we have a long track record of disregarding court orders, nor a long felony history as we have had in some other cases. I do think that at least a bond is warranted here.
Okay, but here's the thing. Let's say he doesn't know about pretrial. He does see 5/24/19 at 9:30 a.m. in courtroom 1D. And he did not go on that date to that place. And that's pretty, on its face, self-explanatory.
I'm not actually sure that that's I don't think that's the court date he missed, Judge. Let me look. Is it? I think he missed a date in July.
Excuse me, Farmer. Sir?
I think he missed a date in July, Judge, for a catch-all calendar. Like he actually showed up, at least my understanding is that he, and maybe that's what Mr. Averett was about to say, is that he did come to court. Mr. Averett, were you about to address the? Yeah. Okay. I'm okay in terms of that discrete issue if you want to address it to the court.
Go ahead, sir.
Yeah, I did show up to court. Plus, when I left out of here, I had no plan at all anyways. I just left back to the streets. And this time I got a plan. My family's waiting on me. I got that program waiting on me. And that's just where I stand with it.
But will you just let him know? Because we actually did talk about this. Mr. Averett, I believe, did come to court in May, and which is reflected in Odyssey. He doesn't have a bench warrant from the 24th of May. They do what they often do in non-complex and APH, and then further notice them without a date. He doesn't have an address listed in the system. And then, well, he has the wrong address, more correctly. He's homeless, yes. Ultimately goes to live with his mother. And then they send a notice to a catch-all calendar for July. And it's that catch-all calendar that Mr. Averett doesn't show up to.
Yes, sir.
And in that bond order, it says, if you change your address, it is on you, right?
Yes, it does.
Order for bond. Where is it?
It also says that he's assigned a
right here.
services.
If the defendant changes address, the defendant immediately shall notify in writing the clerk of Superior Court. Again, not much explanation needed.
Mr. Averett's holding a hat in hand, Judge. We're not saying he's done everything he's supposed to do. We couldn't possibly say that with a straight face. We're just asking for an opportunity, given that these are nonviolent charges, that he doesn't have a felony history, that we do have a plan in place, that any contact with the system has been a consequence of his health struggles with addiction, and in light of the COVID crisis. That's why we're asking for a bond. We're not by any means saying that he is an angel or that he's done even everything he was supposed to do here, but instead that it wasn't a willful disregard of the court's order, that he was struggling with addiction at the time and homelessness, that we have a better plan now, and that we do have reason to believe he'll be able to remain clean and stable until we can come up with a more long-term plan.
So you want a bench warrant set aside and you want signature bonds on both cases?
That is correct.
No.
And in the alternative, Judge, I'd ask that you set a reasonable bond. I don't believe that $66,000 is I understand that what the allegations are, but Mr. Avery does deny that those are his drugs. He doesn't have anything like that in his history. We'd ask for $5,000 on the 851. If Your Honor is not, as you indicated, not inclined to grant a signature bond, $5,000 on the docket, the 19 SC docket ending 851, and $10,000 on the docket ending 149, with a 10% option, so that his family has any shot at all of trying to get him out, as well as.
Well, and here's the problem. How's he going to sign this bond order? You know, when he,
It's on the record here, Judge. I mean, we can ask that the transcript be submitted into Odyssey if necessary. I mean, he's on notice. And I do have good contact information for his mother. I spoke with her as recently as this morning, actually. She called me back.
How old is Mr. Avery?
37.
Mr. Avery, you're a grown man. Don't be relying on your mama to keep your court date straight.
Yes, sir.
Because if you miss a court date, it ain't mama that goes to jail, it's you.
Yes, sir.
Sorry about that, guys.
And what is the address that he would be living at?
In Covington. Mr. Averett, do you know the address, your mom's address?
I don't know about heart now, no.
Okay, I can get it in 2 seconds. I actually just get her on the phone right now if Your Honor wishes.
No.
Okay.
I just want that address to be filed with the court.
Okay. All right. I can send that address to Ms. Mejia, the case manager, so that it can be part of the order.
Mr. Everett?
Sure.
These aren't nickels and dimes anymore. And I see you've had a bunch of stuff null-prossed or dead docketed before. So your charmed life, you know, your 9 lives, you're running out of them.
Yeah.
You know, maybe that was the problem. You got too many little taps on the wrist before. So you think nothing's going to happen to you this time. There are consequences for actions. I understand the presumption of innocence, but I also understand a bench warrant. I understand not coming to court, and I understand not following directions and not changing your address. Because if you were living out in Covington, that's what the address you put on. And if you're supposed to go to pretrial, you go.
Sure.
You know, if you'd have shown up at pretrial at any time between, you know, May or June and December, and pretrial does call trying to find people, but you can always go to pretrial. They're there 5 days a week. No, right now I'm going to deny it. I'm gonna keep the bench warrant. Mr. Jenkins, I want you and Ms. Ulrich to talk. See if you guys can come to a resolution.
We'll be talking the next few days, Judge.
Right, and again, we do have, y'all think about what 6 cases you want on, I forget which, it's the week of the 27th. I forget which day I have, but get with Ms. Mejia on that too.
The week of May 27th?
Yeah, I think, hang on. Calendar. Oh, yesterday was Wednesday. Here we go. Here we go. Final list. I will be Wednesday afternoon.
Okay.
Which is the 27th. Okay.
Yes.
All righty.
All right.
Sounds good, Judge.
Thank you all.
I'll be sending this to you, Anna. So look out for your email.
Okay, and Mr. Averett, I just want you to know we're in conversation. I've been expressing what we want to the district attorney, and we're going to keep talking.
Good. Thank.
Sure.
And drug court doesn't sound like it's a crazy idea to me.
It doesn't. Thank you, Judge.
All right. Thank you all.
Thank you, Judge.
Miss Mejia?
Maybe be excused.
You may. Thanks for coming,
Thank
Mr.
you, Judge.
Allen.
Yes,
Thank you,
Judge.
Mr. Forte. I appreciate it. And are you still there, Miss Mejia?
Yes, I am.
Okay, I got all these files. I'm gonna stick
Okay.
them in your, I'm gonna stick them in your chair, okay?
Okay, sounds good.
Okay. Thank you all.
Have a great one, Judge.
Yep.